attention.
Yes.
Supplementary list, item number 1.
Supplementary list. Supplementary.
My Lord, this is a public interest litigation, my Lord.
Yes.
Wherein, my Lord, the petitioner is raising the alarming issue of accident and casualties caused by two-wheelers. And, my Lord, representation also, my Lord, was...
Petitioner is?
He is an advocate, my Lord,
Okay.
of this bar. Now, my Lord, we...
meets the requirements of a public interest litigation?
Yes. And my Lord, we had filed RTI applications, my Lord. We received the reply. If my Lord will come to page number 19. This is just a period of, within a period of 1 year, my Lord, there is 21 number of casualties and 28 injured person, my Lord, due to reckless riding of two-wheelers in the state.
21 people died?
Died. And 28 injured. It's just, and this number is not limited here. Yes. This is mostly in East, Maureenkelang also is there, my Lord, all over the state.
Maureenkelang falls on East Khas Hills.
Yes. And my Lord, this is within a period of 1 year. Thereafter also, my Lord, there are many casualties, my Lord, which has taken place. My Lord, if my Lord will come to the next page, page number 22. This is where a Sananman student of class 11, my Lord, sustained injuries when he was hit by speeding two-wheelers. And again, my Lord, one woman dies in accident, minor rider held, my Lord. There are multiple of, my Lord, incident, even next page also, my Lord, page number 24.
No, we mean to say that the police or the traffic is not doing enough to...
Not enough, my Lord. And my Lord, what we are praying here, my Lord, we have also filed a representation before the Superintendent of Police, my Lord, and there is nothing that has been done from the police side, my Lord. And there is, if some direction can be given, my Lord, to the state to constitute a committee of experts, my Lord, to find out the reasons, and they can provide some recommendations.
Come later, let us see first what the state
and to
has to say.
Install some speed detection devices. There are devices, my Lord, which can detect the speed and which tells the driver also what is the speed, and if he needs to slow down, my Lord, it reflects in the board itself.
In the?
In the display board itself, my Lord. So if this...
display board of whom?
Which is put in the road, my Lord. So if these measures are taken, my Lord, we can...
two-wheelers?
My Lord, mostly on two-wheelers, my Lord, these petitions.
Yes, Mr. Shulai.
Let me have instruction, Your Lordship, because going by the news...
But that's correct. Another thing which
it's
we've
not
seen
that
is
the police are sitting idle, Your Lordship. Going by the news, Your Lordship, we have seen that police, they are busy on the road
you
checking...
see, now young people are on
correct,
two-wheelers.
absolutely correct, Your Lordship.
And they have a lot of excess energy. You see, so the energy should be channelized and put on instead of speeding on the road. That's the thing. You can't blame them also in a way that they have that, when you're at that age, you feel you're invincible.
And maybe some awareness in the school and colleges, my Lord, that will help.
No, it's only that, you see, the only deterrent is, it's a deterrent of a fine or
fine. And my Lord,
or
after
impounding of license
after 2019 amendment, my Lord.
In other countries, they'll seize your vehicle,
yes.
You won't be able to drive for 6
right.
years.
So if these measures are strictly imposed, my Lord, then to some extent we can reduce these accidents, my Lord.
I heard Mr. N. Sankon, Leonard Counsel for the petitioner, Mr. N.D. Shulai, Leonard AAG, with Mr. Khan's present on behalf of all respondents. No further interest call for stop. This PIL is directed against the failure on the part of law enforcement agencies to enforce stringent provisions of the Motor Vehicles Act 1988 with regard to reckless and negligent riding of two-wheelers at high speed within the district. Stop. Another counsel has drawn the attention of this court to the information received via an RTI application, which shows that there have been in the period from
Period is mentioned there.
Period from? Period of 12 months.
Yes.
From 30th of July
My lord,
2022.
30/07/2022 to 23/7/2023.
From 14/7/2020, no, 37/2022, 23. 37/2022. No, this is 23. 37/2022 to.
To my lord, 23/4/2023. Or 23/7/2023, my lord.
23/7/23.
Yes.
Apa mo siya kato?
24. This is this one. Oh, yes.
They have been 31/7/23, right? 31/7/23. They have been how many fatalities?
My lord, 21 casualties and
There have been 21 fatalities
and 28 injured. My
and
lord.
28 injuries due to reckless driving at a high speed. Stop. He therefore prays that appropriate directions will be issued to direct the traffic enforcement authorities to strictly enforce the Motor Vehicles Act and to install proper checks at strategic points to stem this menace. Stop. Next paragraph. The AG at this stage is directed to obtain instructions and also to instruct the traffic enforcement agencies as to the importance of adherence to the traffic safety rules. And other requirements to curb this menace. Yes. Especially taking into account that the festive season is around the corner. Copy of this order be made over to the Learned EAG in the course of the day for transmission to the authorities.
Come after vacation, your lordship.
Just a matter of a vacation, yes.
Apply, your lordship.
Oblige.
You send that, you give the order to the SP traffic.
I'll do.
Oblige.
Item number 2.
Lordship,
Yes.
Lordship, by this writ petition, we challenging the order, judgment or order dated 03/02/2023, passed by the members of these learned members of Central Administrative Tribunal Guwahati.
Yes.
So what has happened in this case is, Your Lordship, the respondent was arrested on a criminal case charged under section 420 and 468 IPC. He was arrested on 19/6/2012. So then subsequently, Your Lordship, the respondent was released on bail on 9/7/2012. Then after releasing on bail, Lordship, then he approached the office of the petitioner, wherein he was suspended because he was already in custody for 48 hours. So as per rules, he was suspended
Yes.
by order dated 06/07/2012. Then what has happened here in this case, Lordship, since the criminal case was pending for a long time, so the respondent was reinstated in service. After reinstating in service, Lordship, then as the criminal case also disposed of, and by judgment and order dated 13/1/2020, the respondent was acquitted on ground of benefit of doubts.
Okay.
So after the acquittal order, judgment and order, Your Lordship, he approached the office of the petitioner. Lordship, if Your Lordship comes to page 54 of my petition.
Yes.
Yeah, Lordship, this is the letter representation written by the respondent for the release of the grant of area pay. So by this letter, Lordship, Then the office of the petitioner, if you come at page 55, Lordship.
Yes.
Yeah. So by this order, Lordship, let me read this order with reference to the application dated 15/7/2021. Shri so-and-so, now so-and-so is hereby informed that the area pay consequent upon the grant of first financial upgradation under MACP scheme in the pay level 2 with effect from so-and-so has not been considered to be given to him as he was acquitted in the disciplinary case against him with benefit of doubt.
What happened before the scat? Then what happened after that?
Yeah, then, Lordship, we will kindly come to page 121, Your Lordship. This is the order which is under challenge.
Now, what did they find? What are the findings?
The finding is that, Lordship, here, I'll read you the relevant portion. Portion is that paragraph 10, Your Lordship. 125, page 125.
Yes.
After taking into consideration the submission of both sides and on going through the documents placed on record, we are of the considered opinion that the applicant is entitled to get benefit of MACP from the stipulated date with effect from 31/12/2014, as reflected in the order dated so-and-so. Therefore, respondents are directed to provide appropriate benefit to the applicant within the period of 3 months from the date of the receipt of this communication of this order. So what has happened here, Lordship? If Lordship may kindly come to page 56, Your Lordship, annexure 10.
1 second. Yes, please issue notice, Ms. Karampla.
Yeah,
Yes,
Lordship, what has happened here? Lordship, what has happened here is this is the office memorandum issued by Ministry of Personal Public Grievances and Pension.
Yes.
So, Lordship, here, if you come to paragraph 3,
On
paragraph
conclusion,
3 of
yes.
this office memorandum.
Yes.
Lordship, for your kind reference, Lordship, I'll take you to page number, paragraph number 10 of my petition, which I have reproduced because the letters, they are very, the words are, they are very small. So kindly come to page number 10, Your Lordship, paragraph 10, Your Lordship, of my petition. Yes, Lordship.
Yes.
So if you come to this paragraph, Lordship, at line number 1, 2, 3, 4, okay, the highlighted one, Lordship.
Yes.
Yeah. Action after completion of the disciplinary case, criminal prosecution. On conclusion of the disciplinary case, criminal prosecution, which results in dropping the allegation against the government servant, the seal cover or cover shall be opened. In case the government servant is completely exonerated, the due date of his promotion will be determined with reference to the position assigned to him in the finding kept in seal cover covers, and with reference to the date of promotion and his next junior. On the basis of such position, the government servant may be promoted if necessary by reverting the junior most officiating person. He may be promoted notionally with reference to the date of promotion of his junior.
Okay,
However,
no, one thing, Mr. Karampla, is like this. Now, you are aggrieved because you say that you are the authority that should determine whether arrears should be given or not. Now,
Yes, Your Honor.
in your
That is my
discretion.
case.
But the thing is that now the tribunal has decided that he should be given MACP, and we issue notice. Let him appear. Yes,
Yes,
but
Lordship.
here, Mr. Karampla,
Thank you.
the counsel with petitioner, issue notice, returnable in 3 weeks. Steps will be taken by receipt within 1 week. Yes, list accordingly.
Lordship, there's a miscase also, Lordship.
No stay at this time. Yes,
Lordship, till the next returnable date, Lordship, please, till the next returnable date, Lordship.
Yes. Now the order was passed when of the tribunal.
Lordship, the order of the tribunal was passed on the on the 3rd February 2023, Lordship.
Then, how ask for stay? If it's immediate, yes.
Item number 3.
Lordship, but then,
Miss case, we consider next date. Yes.
okay, Lordship. Highly obliged, Lordship.
If you are already complied with the order, I suppose. You already
Not yet,
complied with the order.
Lordship.
Then you'll be in contempt. The 3 months' time is already elapsed also for compliance. Yes.
That's what, Your Lordship. So that's why I'm seeking for stay, Your Lordship. If Your Lordship, please.
No, we'll examine the next date. Yes. Issue notice first. Yes.
Oblige, Your Lordship.
Item number 3.
May I please, Your Lordship?
Yes.
Well, it's,
Yes.
this is a writ petition challenging the impugned notice, well, it's dated 10/11/2023, issued by the Income
Where is
Tax
that?
Department. Your Lordship should find it at page 32, well, it's Annexure 6. What has happened here is, well, there was a demand that was raised against the petitioner. There was an assessment. Against that, well, there is an appeal pending. The acknowledgement of appeal, Your Lordship should find it at, well, it's Annexure 4. Page 25.
25.
Yes, Your Lordship.
Yes, assessment year. So yes, assessment year 2016-17.
Yes, my lords.
Okay.
Your Lordship will kindly see, my lords, the details of the order appealed against. That's serial number 2, my lords. Last row, Your Lordship should see date of order 14 March 2022. This was the order that was passed, my lords, against which we have filed an appeal.
Okay.
Now, while the appeal is pending, my lords, and
Yes.
Annexure 6, my lords, another demand has been raised at page 32.
Yes. For the same period.
Yes, my lords. Assessment year 2016-2017, Your Lordship should see, my lords, on, right at the top.
Yes.
PAN number so assessment here. There it is written, my lords, assessment here.
Yes. Who's the paying for the tax authorities?
I am, Lordship.
You accept notice?
I'll accept notice.
Yes. Sir, Mr. K. Polnes, counsel, assisted by B. Karmoplan. Stop. This application is has been preferred against the impugned assessment order dated 14/3/2022 and impugned notices dated 14/3/2022 and 10/11/2023, respectively issued by the respondents. Stop. It has been submitted by the council that there is an appeal pending for the same assessment year, the details of which are enclosed in Annexure 4 to the writ petition. Stop. Further submitted that in this view, it is further played that in view of the pendency of the, you're asking for stay of the
Right.
appeal, that the demand be kept in abeyance for the time being. Stop. Anything to say?
No, Lordship, I'll take
Yes,
this.
Mr. S. Pandey is present on behalf of the
Respondent
all the
2 to 8.
respondents.
2 to 8, Lordship.
Respondents 2 to 8, and M. from Thau for number 1, so no further notice required. This is matter after 3 weeks. Stop. Just prior interim, the impugned notice, demand notices dated so and so shall remain stayed until the next date.
Hallelujah.
Daily list, item number 1.
Traffic.
But in terms of Your Lordship's last order,
Oh,
Well, it's, an affidavit was required to be filed by the state.
yes. Where's affidavit? Mr. Khan.
Lordship, this is regarding,
Yes, where's the affidavit?
we have filed the report today, sir, Your Lordship. The affidavit.
Where's the report? We asked you to file a affidavit, no, the status. The last time was very sketchy. Yes. In spite of the order dated 4/12/2023,
Apologies.
asking for a detailed affidavit we filed with regard to the status of all the five packages. Yes, Mr. K. Khan today has prayed for some more time. We'll adjourn it. Yes.
Well,
This is the matter after vacations. Affidavit should be on board by the next date. Yes.
obliged.
Take this back.
Apologies.
Good.
May it please your Lordship. My Lord, seek your Lordship permission to move a unlisted matter, my Lord. Urgency is because, my Lord, I am challenging a notice issued by the Cantonment Board to demolish my, what they are alleging unauthorized.
It's already filed.
Yes, my Lord.
If you want to move on unlisted matter, but your Lordship, in the first round of litigation, your Lordship has recused, your Lordship.
Has
Recused from...
Which matter is this?
That's one matter of same million. So I want to mention in courtroom number 4, then they have to seek your permission first and then mention it.
Yes, mention it.
Okay,
Lord, I'd like to mention, my Lord, item 11 in the hearing list. This can be taken after vacations, my Lord.
Where's the regular list?
Regular list, my Lord.
You have objection?
No, Your Lordship.
1 second. 11 a hearing list. 11 years. Sotun.
Please opt in, my Lord. Okay. After vacation.
As of today, no, the hearings are urgent, we will not take it up. Yes. Yes, Ms. Mori.
May it please Your Lordship. Your Lordship, I beg to mention item number 12 of the daily course list. Your Lordship, I pray that this matter may come up after vacations.
2 days for filing of written arguments.
Your Lordship, we are not prepared, Your Lordship.
Where's the petitioner?
Oh, sorry, Your Lordship, I'm responding.
Where's the petitioner?
Yes, Your
You're
Lordship.
supposed to file your written arguments today.
Yes, I'll file today, Your Lordship.
They have what to do about them, they're not filed there.
So far as state is concerned, we are ready to file it, Your Lordship.
We're not ready, Your Lordship.
Okay, just take down this matter, remains part heard.
Yes, Your Lordship.
Yes, written arguments have been, no. You better, since the after vacation, you might as well place the arguments. I thought that since, the weekends are coming, then we can render judgment. Anyway,
Lordship,
this matter
do we have
remains,
to file the written argument today or after vacation?
file afterwards. Let's have might as well have oral arguments. Matter remains part heard, list after vacations.
Oblige,
All right, Your Lordship.
Yes, that's it.
Supplementary list. 1, item number 1.
This is linked with item A.
Number 1.
My Lord, the petitioner.
This is linked with item A, Your Lordship, of the
Oh,
regular
there's two
list.
supplementary lists.
My Lord, DLA 1.
Yes. No, there are two supplementary lists. There's another supplementary list. Yes.
My Lord, the writ petitioner has completed his 2 years course, DLA also, MTech also. Now, the prefect, my Lord, after 2009, RDE,
Yes.
on 23rd August 2010, NCTE laid down the norms, minimum norms for appointment of an assistant teacher. And the 2 years DLA is one of the mandatory criteria. Now, pursuant to this, my Lord, thereafter, in 2017, the second proviso to subsection 2 of section 23 of the RDE was amended. And it provided that those who are already appointed as the LP school, in the government school, without having requisite qualification as per the NCT norms, they are allowed to obtain the qualifications through NIOS. Pursuant to that, my Lord.
But that means to in-serving teachers who don't have GLET.
Yes. Okay. In serving only, my Lord. Pursuant to this, my Lord, on 22nd September 2017, NCT has issued a notification that allow all the in-service untrained teachers to undergo for 2 years initially through NIOS, which subsequently they reduced to 18 months only, to obtain it within a period of 5 years, with effect from 2015 to 19. So that was only for the in-service. Now, what happened? The Meghalaya also, my Lord, the advertisement was issued, and Lordship may just take that one, page number 41, NCT norms. Page number 41.
41.
41, my Lord.
Okay.
23rd August 2010.
41.
My Lord, it reads class 1 to 5, senior secondary or such 50% marks and 2-year diploma in elementary education by such and such. So, or senior secondary with such 2-year diploma in elementary education. So it is one of the criteria. Thereafter, my lord, the advertisement for this Meghalaya, that the English subdivision was out, page number 44.
Page number?
44, madam.
Yes.
Madam. This was published on, my lord, 30 October 2023. Now, the number of vacancies is 235. My lord, for unreserved candidate is this one, and my lord, for the ST is this much, and this. Now, the qualification number, my lord, criteria number 3, DLED pass certificates, my lord.
Compulsory, yes.
Yes, this is as per the norms of 2010.
NCT, yes, okay.
Now, thereafter, my lord, what happened? In the case of, my lord, the Tanvir Singh case, regarding the B.Ed candidates.
In the case of?
Regarding the B.Ed candidates, yes. My lord, where, my lord, the Supreme Court say that B.Ed candidate, the candidate who has a B.Ed is not eligible for appointment as an assistant teacher.
In primary schools?
In private schools. The lordship, the judgment was delivered, and my lord has referring to that, has delivered another judgment, page number 46. 46. Now, thereafter, page number 61, my lord, the new Supreme Court judgment, my lord.
Yes.
Page number 61. Now,
yes.
My lord, this judgment was pronounced on 28 November. And the advertisement here is the 30th November. So before completing the date of submission of the particulars, the Supreme Court has pronounced in this case. The brief background of this case, my lord, is that after, my lord, Supreme Court, NCT allowed for 18 months course. My lord, in 2020, what happened? Tripura High Court and Patna High Court has rendered a judgment that there is no distinction between 18 months and 2 years course. It should be equivalent. They are equivalent. So that was the order. In view of that, my lord, 2021, the NCT has issued administrative instructions adopting the Patna High Court order that yes, we will allow the 18 months
open
in
university, open, I mean like correspondence pass.
Yes.
Yes.
To open for everyone. Now coming to knowing this one, my lord, what happened on, my lord, for 6 January 2021, the Chief Secretary of the Uttarakhand government has issued an order directing the all education department to allow the 18 months in NIVS candidates to face the selection process also. Now, shortly, my lord, he came to know that the state government has also framed its own rule, Service Rule 2012, pursuant to NCTE. And under the NCTE, it is a full-time course of 2 years diploma. 2 years diploma. Therefore, on 10 February, my lord, 2021, he withdrew his letter. The letter is 6 January 2021. He withdrew. Now, his withdrawal letter dated, my lord, 10 February 2021 was challenged by the Uttarakhand High Court.
Dated?
Dated, my lord. 10, my lord.
10?
His order, my lord, 10 February 2021, issued by the Chief Secretary of Uttarakhand, was challenged by the Uttarakhand High Court. Now, Uttarakhand High Court, passing a government judgment, my lord, judgment dated 14 September 2022, rendered a government judgment that 18 months NIS candidates and full-time 2 years are equivalent. So, being agreed with this, the matter reached to Supreme Court, and Supreme Court has pronounced this judgment, my lord. I just take the operative portion of this very judgment, my lord. My lord, we come to page number 91. Page number 91. I may start from my paragraph 35, my lord. As already discussed here in above, NCT Recognition Order 22nd September 2017 was issued so as to give an effect to the directives of the MHRD and such, so as to provide a one-time window to the teachers who were already working and who, in terms of 2017 amendment, were required to acquire minimum qualification prior to 1st April 2019. The said order in any case cannot be held to be a direction to the state of Uttarakhand to act in contravention of its 2012 service rules and the advertisement issued on basis of such service rules. We further find that the finding of the High Court that 18 months DLED diploma OTL course in elementary education conducted by NIOS is equal to 12 years, 2 years diploma is erroneous. There is no notification to that effect issued by the NCTE in supersession of its notification dated 23rd August 2010 and such, wherein it provided minimum 2 years diploma as a minimum qualification for appointment of teachers. As the cause of repetition, we clarify that the notification numbers dated such and such were issued in exercise of its powers conferred under Section 23(1) of the RTE Act, whereas recognition order dated such and such order was passed in pursuance to direction issued by the such and such. Assuming for a moment that the 18 months DLED diploma by NOS through ODL mode is equivalent to 2 years diploma in elementary education recognized under the notification NCTE such. The next question that has to be answered is, can the state be prohibited from prescribing the minimum qualifications which is higher than that? A similar question arose for consideration such, my lord. I mean, come straight to my lord. 38. We therefore find that the High Court has erred in directing the state government to consider the candidates who did not qualify as per 2012 rules and as per the advertisement based on the service rules, particularly when the 2012 rules and the advertisement were not made under challenge. The High Court, in our view, could not have issued such a mandamus contrary to its service rules. That leaves us the question as to whether...
Just sorry to cut you short. The thing is that you are saying that now, you are praying that there are candidates here who have a correspondence course 18 months. Like this in Meghalaya.
But all of them, my lord, here
Are they in service candidates?
They are not in service candidates.
You are in service candidates or
I'm also not in service candidate. I'm one of the contractual teachers, and some of the respondents are contractual teachers. But one-time window was open to those who are permanently appointed, but not have.
So you say that the thing is that, but the Uttarakhand judgment is based on the rules of Uttarakhand government, correct?
Yes. Yeah, Uttarakhand rules also, my lord, may I clarify. Uttarakhand rule also requiring 2 years diploma is in pursuance to NCTE notification.
So NCTE notification says that nowhere has made it equivalent. You mean yes. 18 months and the 2 years.
Yes, yes.
So if they have not made it equivalent, that means they're ineligible.
Yes, ineligible. But in this case also, my lord.
So you feel that there's some respondents here who are not eligible as having 18 months.
My lord, may I take the impugned notification? Where may I show, my lord? Page number 113. This is the final select list, my lord. It was issued on 11th, my lord, December. This is to notify that the...
But selection is already underway, Mr.
My lord, it is underway, therefore. Underway, my lord. I'll come to the lordship permission. Personal interview for the selected MTech pass candidates for the post of assistant teachers of government LPs under Tatingiri subdivision shall start from such and such onward. The selected candidates are requested to inquire from the notice board the date and their names, which is scheduled from the date such and such. Now, my lord, 13 to 21 is for ST candidates, which is going on. And I'm...
Now, how many respondents are you arrayed here?
My lord, the writ petitioner and the respondents are the UR candidates. My lord. UR candidate interview will be started from 4th January. 4th January. And my writ petitioner, my lord, his interview date is scheduled on 8th January. 8th January. Now, my just...
Where are you? Where have you said that?
Well...
how do you know other interview dates?
May I come to
Where
that?
do you find that?
May I come to that? Page number, Lordship, kindly come to page number 137. Well, approve MTech candidate list for personal interview under Datangiri subdivision started from, my lord, 5th January 2024. Now, my name would be appear, my lord, page number... My lord, Lordship, kindly come to page number 143. Page number 143. And his name is serial, my lord, serial number 19, Mr. Alon is there. Other private respondents also there, 17 also.
Okay.
It is fixed, my lord.
So what do you want now?
No, my humble prayer is, my lord, the lordship kindly issue notice, and since the interview has been commenced already, my lord, I invoke this jurisdiction, my lord. My duty is my prayer is to be fair, my lord. Therefore, my issue may be noticed. In interim, we file interim applications, my lord. Since the interview is undergoing, my lord, lordship may make an order that the final results.
Subject to the petition.
Yes, subject to.
You don't need to be an interim prayer for that. That is a known thing.
Yes, madam. That observation may be there. Otherwise, they may publish it and they'll finalize the selection process. So, lordship may make that.
This is your lordship. Lordship, from the pleading of the writ petitioner, it is seen that there are 326 candidates, your lordship, and the petitioner is only aggrieved with the respondent number 17 to 19 only, your lordship. What are
17 to 19? How many respondents?
7 to 19. That means altogether 13 candidates.
Respondent number 4, my lord.
Number 7.
That is what, lordship, that is the pleading at page 10, paragraph 11, your lordship.
Well, a private respondent will start from number 7 onwards. 7 onwards. These are the candidates. We are aware that they are only 18 months. There are many candidates.
Yes, anything else?
Lordship, can you see now the selection process is...
no, of course, that he concedes.
In full swing, your lordship.
Anything else to say on the merits of the matter, I'm saying?
Lordship, kindly come to the advertisement. That is the advertisement of at page 44, your lordship.
Okay.
These are the required qualification, your lordship, in which all the private respondents, they do have the qualification, your lordship. That's why they have been selected and called to face the interview.
His case is what? What's his case?
His case is that these people, they are having that 18 months.
His case is that what was prevailing prior to the advertisement, after the advertisement was issued, does not no longer exist. Advertisement issued after judgment of the Supreme Court. So he's trying to apply existing law. Existing law as pronounced now.
The advertisement is of...
Exactly. Advertisement is when, judgment is dated when?
The judgment of this Honorable Supreme Court is 28/11, if I'm not mistaken.
And advertisement?
The advertisement is 30/10 of 2023.
Okay.
Prior to that,
he's saying that
prior to the judgment of the Honorable Supreme Court.
Whatever it is, he's saying that by applying existing law. By applying existing law has been held now since prior to selection, this judgment has come out. Now, whether you are bound by existing law or not, it amounts to that. Your case, what you have to defend is that the existing law as it was there when advertisement issued, allowed us to issue advertisement. You're addressing the point that he's raised.
Can you see, your lordship, the prayer made, your lordship, that advertisement is not put under challenge, your lordship?
He's not put he's put a section person under challenge. See what is written here.
Can you see, come to the prayer, lordship?
Simple thing is that, whether he can apply...
Kindly come to the prayer, lordship, at page 21.
His challenge is like this.
He's challenging only with respect to the respondent numbers 17 to 19, your lordship.
7 to 19, yes.
7 to 19.
And other similarly socialist candidates.
Similarly, seated candidate, your lordship.
Senior Counsel Mr. H.L. Chaleso for the petition, with so-and-so for the petitioner. And Mr. N.D. Shulailand, AG, with so-and-so's accept notice on behalf of respondents number
1 to 5, or 1 to
5. Notices to be issued to remaining respondents within 1 week. So, the facts are set forth by the petition is that the candidates who have been arraigned respondents, namely 7 to 19, are ineligible to continue with the selection process, which is advertised by the advertisement dated
30 October.
30/10/2023.
2023, inasmuch as they don't possess the requisite qualification as prescribed by the NCTE norms, that is, possession of a DELED qualification on completion of a 2-year diploma course. Stop. Mr. Chandraiso submits that the respondents 7 to 19 only hold diplomas of DLED which of 18 months obtained through correspondence course, and as per the latest judgment, Honorable of the Supreme Court, that makes them ineligible to be eligible for selection. Stop. He therefore prays that appropriate orders be passed directing that these candidates be not considered for selection. These candidates are the similarly situated candidates be not considered for selection. Stop. Next is Andy Shulai. Next paragraph in AAG submits that the selection process already underway, and as such, no interim orders are called for at this stage. Next paragraph, upon hearing the counsels of other parties.
May I make one submission here? In this matter, your Lordship is find that 18 months diploma is for in-service candidate is valid.
No, we're not going to pass any orders. We're not going to pass interim orders, Mr. Amit Kumar. We're not passing interim orders. Oh, no.
So I am obliged. Yes, obliged.
No interim orders are called for this stage. After that, I'm heading to next paragraph. How are you? Yes. And considering the matter, at this stage, no interim directions are called for. Stop. Let the respondents file affidavit on reopening. Yes.
Lordship. Well, only prayer, Lordship, in my miss case. Lordship, they will complete it, they will result it, they will announce the result.
Mrs. application will be considered on next date.
Apply, Your Lordship.
Item number 8.
Item 8 is also connected.
Item number 8 is connected, Your Lordship. In this case, Your Lordship, he has no law cost. He is a non-candidate, Your Lordship.
That matter be called out, Mr. Shulai.
I'm sorry, Your Lordship. Apply.
Yeah, ma'am. We'll take it up. We'll take it in series.
Yes.
I give number 8. Yes, what do you have to say in this matter?
My Lord, here they have filed the affidavit objecting, my Lord. I will give my short reply.
Yes, an affidavit short affidavit has been filed by the state respondents against the prayer of interim stay.
No, Your Lordship, contesting his
law questioning the maintainability.
Maintainability. Yes, limitation. Stop. Mr. Chacharu prays that he be allowed to file a short reply. This is a matter of the vacations. Yes.
Apply, Your Lordship.
Supplementary list item number 1.
May I please, Your Lordship? May I please, Your Lordship?
Yes, Mr. Chanda.
My Lord, this is a contempt petition, Your Lordship. Lordship, by judgment and order dated 25/5/2027, page 8, Your Lordship, whereby 3 months' time has been granted by this Honorable Court to frame the new recruitment rule. The petitioners are stagnating for 20 years, more than 20 years, for non-framing of recruitment rules. And now it is 7 months, my Lord. They have not framed any recruitment rule. Therefore, at this stage, Lordship, I prefer issue of ownership. Page para 34, Your Lordship. Page 22, operative part of the judgment. Para 34 in the bottom, last 2 lines, 3 months, within 3 months, Your Lordship. Lordship may look into para 34.
My Lord, in fact, we have filed an application for extension of time for compliance, my Lord, and that is listed today before the court number 3, my Lord.
My Lord,
what I pray, my Lord, both of the matter will be listed together, my Lord. This contempt along with the application for extension, my Lord.
Let the notice be issued, my Lord.
Notice is not called for, my Lord. Since you filed
application extension,
you'll
take it up after vacations. Yes, has been submitted at the bar that an application for extension of time for compliance of the judgment order dated
25. Order dated, my Lord, 25/5/2022. 23, Your Lord. 25/5/2023.
has been filed and is presently listed before court number 3. This is matter of verifications for consideration. Yes.
Item number 2.
Yes.
May I please, Your Lordship?
Yes, Richard.
The import order, Annexure 10, page 72, my Lord. The benefit of fast SCB has been denied to the petitioner only because he did not approve the Honorable Court. Lordship will look into page 72. Page 72,
yes.
Annexure 10, impugn order. Last 3 lines of para 2, Your Lordship.
Okay, heard Mr. M. Chanda. Issue notice Dr. M. Mosikal at DSG with S. Thao, except on behalf of all the respondents. No further notice called for. List after vacations for affidavit instructions.
Deeply.
Item number 3.
Now he's come to the court, he extend the benefits.
Fine.
Yeah, please, Your Lordship. Can this matter be taken up after some time, Your Lordship?
Why? What's the matter about?
The conducting counsel has occupied the other courtroom, Your Lordship.
Yes?
The conducting counsel is occupied the another courtroom, Your Lordship.
This pertains to the fire brigade field.
Item number 4.
May it please Your Lordship.
Very familiar name, anyway.
Lordship, the petitioner herein, he's the president of the managing committee of a local aided school, my lord. Petitioner, my lord, is aggrieved by the refusal of the district education authorities in according permission or approval of the reconstitution, a small reconstitution of the managing committee, my lord. I'll just take 2 minutes, my lord. What has happened is, if Lordship kindly looks at Annexure 2, that is page 17.
Yes.
This is the notification through which the managing committee was constituted. This was in 2021, my lord. 11 persons were constituted.
Type copy of this one?
Yes, my lord. On the next page.
Okay. Yes.
Number 2 on that list, my lord, is today's respondent number 5. He's the secretary.
Muhammad Mumtaz?
No. Number 2, that is Dilawar Swear, my lord.
Number 2 is the respondent.
Number 5, private respondent number 5, before my lord today. Also, my lord, what is important is...
And the petitioner is number 1.
Petitioner is the president, number 1, my lord. The clause number 1, just below the list, my lord, that is very relevant. Managing committee is to hold meeting once in every 3 months or maybe more if need arises. Any member who remains absent for 3 consecutive meetings without intimation is liable to be removed from membership, and the name of the substitute may be submitted to this office for necessary approval. So clause number 1 very clearly, my lord, relates to meetings, etc., and the number of meetings one is supposed to attend, my lord. Now, they've been functioning since 2021. Recently, my lord, in the month of July, that's when certain problems arose. If Lordship looks at page 21. On 11th July 2023, my lord, a complaint was received from the pro forma respondent. This complaint, my lord, is on the next page. If Lordship kindly allows me to go through the complaint.
No problem. Yes.
Page 22, my lord, para 1. That Shri so-and-so, Secretary Managing Committee so-and-so school, appointed the following 2 teachers in so-and-so school in flagrant contravention of law and rules. Number 1, 2. Next para, that the appointment of the aforementioned teachers were made surreptitiously without following the procedure for appointment of teachers. Number 3, that I have come to know from reliable sources that the above-mentioned secretary of the managing committee of the school aforesaid had demanded and received bribe of rupees 5 lakhs only from each teacher named above for their appointment as teacher in the school aforesaid. Next, that the secretary of the managing committee named above has fraudulently obtained approval for the appointment of the teachers named herein above by way of falsification and misrepresentation of facts, for which he is liable to be prosecuted in a court of law for the offences he committed under relevant sections of the IPC. So, Lordship, there was a complaint in respect of the respondent number 5. Allegedly, he had taken some bribes, my lord. Now, obviously a serious complaint. While we were still processing this complaint, my lord, sometime later, page 24, my lord, yet another complaint was received. This is from 3 persons who were members of the previous managing committee prior to 2021, my lord. I'll just read from the second paragraph, my lord, of this complaint. We have come to learn that the secretary of the school, via his letter dated so-and-so, forwarded a copy of the resolution alleged to have been adopted in a managing committee meeting dated so-and-so with regards to the appointment of 2 teachers against the vacant post in the LP section. In this regard, we are to say that we never attended the said managing committee meeting and our signature appears to have been forged or manipulated in some other manner. we are not aware of the selection committee ever constituted by the managing committee for the interview of candidates in this regard. In view of the above, we are not a party to the resolution with regards to the appointment of the 2 teachers, and all the actions in this connection appear to be a manipulation by the secretary. So, Lordship, now about a month after the first complaint, another complaint regarding forgery, my Lord. Definitely a serious situation emerged, because of which, my Lord, page 25, we requested Respondent 5, the Secretary, to convene a meeting of the Managing Committee to discuss these complaints. He refused to convene the meeting. In fact, he refused to accept this letter itself. Subsequently, my Lord, having no other option, the Managing Committee held a meeting minus the Secretary. Certain resolutions were passed, my Lord. That is at page 27, my Lord. Page 27. These are the minutes of the meeting, my Lord. Certain resolutions were passed. Just 3 resolutions are important from this, my Lord. Page 28 may kindly be looked at. Resolution number 3, my Lord, towards the bottom. All the members of the Managing Committee who were present in the meeting proposed no confidence motion against Mr. So-and-so, Secretary, Managing Committee, stating that his retention as Secretary, Managing Committee, Madrasa So-and-so School, is detrimental to the school on account of his reported illegal activities. Accordingly, the Managing Committee resolved as hereunder. Resolved that Mr. So-and-so shall cease to be the Secretary Managing Committee of So-and-so School, Shillong, with immediate effect till further orders of the Managing Committee, so as to ensure that evidences were not tampered with and witnesses were not induced and intimidated, and no destruction or disappearance of evidence is caused. Meanwhile, an in-house inquiry may be instituted forthwith. Lordship, the first resolution number 3 was essential because the records were all with this person, number 5. So to ensure preservation of records and non-tampering of evidences, it was decided that he should be removed from his post. Resolution number 5, my Lord. Number 5, after cessation of Sri So-and-so to continue as Secretary Managing Committee decided to induct So-and-so as the Secretary of the Managing Committee of Madrasa So-and-so School, and a resolution to effect was adopted by the Managing Committee as hereunder. Resolved that So-and-so member Managing Committee be inducted as the Secretary of the Managing Committee of So-and-so School.
Okay.
And
what happened after that?
Now, next page, my Lord, page 30. As is required, we are required to get these approvals, these resolutions approved by the respondent number 4, my Lord. So we, through the letter at page 30, we sent it for approval, my Lord.
Okay, then what happened?
There was also, Lordship, it is important to point out that at the same time, page 32, we also filed an FIR with the police authorities. Finally, my Lord, page 34 is the impugned refusal. This is from respondent number 4, which is the sub-divisional school education officer. I'll read, my Lord. With reference to the subject cited above, I have the honor to state that the prayer for approval on the resolution number 3, resolution 5 and resolution 6 cannot be granted under the following ground. Number 1, according to rule number 1, mentioned in the order number so-and-so, dated so-and-so, is not applied appropriately. I'll just pause, my Lord. That is that rule number 1 which I just read regarding meetings. Absolutely no connection with the issue that that has arisen now, my Lord. Number 2, investigation on the allegation against so-and-so, Secretary so-and-so, is still ongoing, and the matter was registered with reference as Lundinjari case number so-and-so under section 465-471 IPC. Now, he makes a reference to the police investigation. All the more reason I humbly submit that he is removed from his post and kept away from the records, my Lord. Number 3, case number 132 of 2021 in WPC so-and-so related to the Managing Committee of Madrasa so-and-so School under the secretaryship of Sri so-and-so is still pending in the Meghalaya High Court. Lordship, before this Honourable Court, there is a challenge to the legality of the Managing Committee. Incidentally, my Lord, that was filed by pro forma respondent herein, my Lord. That is regarding the legality of the entire Managing Committee has absolutely no connection. Of the present the entire managing, the legality, the formation of the managing committee itself has no connection with the secretaryship of respondent number 5, my Lord. Naturally, my Lord, we objected to this, but there's been no response therein. Now, Lordship, what has we are obviously our contention before this Honourable Court through this petition is that the reasons for refusal, for not according approval, are no reasons at all. So Lordship, a response may have to come from the state respondents. But in the meantime, my Lord, emergent situation has developed over the last 2 months, What has happened, my lord, over the last 2 months, we have not been able to touch the bank accounts of the school, my lord. That is for the reason that the secretary's signature is required.
Yes, state.
Please, Your Lordship. Your Lordship, the allegations that has been made against...
Very serious. I mean, there's a whole process that's been going on in the school.
Yes, Your Lordship. The Secretary, respondent number 5, the allegation. These incidents allegedly took place in the year 2021, Your Lordship. The appointment of those 2 school teachers against whom there is a complaint that they have given bribe to the Secretary was also made in 2021. And now in 2023, Your Lordship, they have come making these allegations against the Secretary. All these years, Your Lordship, the school was functioning smoothly. There was no problem, Your Lordship. Even the allegation that there has been a forgery in obtaining the approval of the Education Department was also done in 2021, Your Lordship. Allegedly in 2021, that alleged forgery also, Your Lordship.
FIR?
So in
FIR was
FIR
2
was
months
in
back.
2023, Your Lordship. After these...
But this is dated 30th August 23.
Yes.
Regarding a complaint with forgery.
Yes, ma'am.
Regarding the earlier.
Yes, but these
and
things...
Even this one regarding the illegal appointment is on 6 July 23.
Yes.
That is after the new management committee came.
Yes, and this appointments were made when the previous management committee was there, Your Lordship, because the new management committee came only in August 2021, Your Lordship, whereas the appointments were made in March 2021, Your Lordship. The appointment of these 2 teachers against whom there
So
is...
you mean to say it's a witch hunt, that's all?
I feel that way, Your Lordship. So the respondent number 5 notice should go to him, Your Lordship, because it appears there is another
Now
case
what's happening
also.
to the school? It's closed now, holidays.
Holidays, my lord, but the salaries of the staff and teachers need to be are stuck because,
Why?
my lord, as I was submitting, secretary's signature is required plus president. 2 signatures required on any
They can't
check.
see eye to eye, so they can't sign.
No, my
side
lord.
by side.
No, my lord. So what has happened is because we have removed number 5 from his post and inducted the other person.
But then has been informed to the
approval
bank,
has
but
not
that's
been given,
he's
Your
not,
Lordship.
he's
We've
just
informed.
Arrangement.
My lord, we've informed, we've shown them our resolutions, but at the same time, the respondent number 5 has shown the impugned letter. So bank is confused, bank is refusing to do anything, my lord. So unless if the impugned letter is stayed, what will remain, my lord, is the resolution. On that basis, at least we can...
The removal of the respondent number 5 from post secretary.
Correct, Your Lordship.
Without the
And
correct
that is-
approval.
Sorry,
by
my
the court, which cannot be allowed.
no, my lord, because no. If lordship kindly looks at the resolution, it is until further orders, my lord. Until further orders.
But he
that-
ceased to become the
See, the thing
secretary.
is that you have not obtained the approval
From the government.
for remote secretary, right? And these incidents happened in 21.
The incidents happened in
These
21.
things they have to be
Lordship.
investigated, they have to be,
Lordship, the
And
incidents...
He should also be given an
Lordship.
opportunity of giving his...
Lordship, completely appreciate incidents happened in 21, but my lord, the complaints were received by us, were filed only
So we
a few months
direct,
back.
you direct him to sign the check, whatever, and you would present sign?
that can
At least the teacher shouldn't be put in.
That's true, my lord. That's true. If lordship can issue a direction to that effect, my lord.
Not your newly appointed secretary.
The previous one.
Respondent number 5, Your Lordship.
Because we've already removed him from the post, my lord. To vest that power in him would be to justify or validate his position.
No validation. It's only an arrangement. If you say that
It's
is
an
your
interim
anxiety,
arrangement, yeah.
that the teachers are being paid, then let the salary be paid by SDSU.
As lordship directs, if lordship directs.
I heard Mr. S. General and Counsel for the petitioner issue notice returnable in 3 weeks. Steps to be taken on respondents 5 and 6 within 3 days. Ms. T. Yangi, the AG was also present on behalf of respondents 1 to 4, so no further notice to the respondents. Next paragraph. Mr. S. General and Counsel for petitioner has submitted that. The respondent number 5, who is the secretary of the management committee of what is the school of
Madrasa.
Madrasa
Himayatullah Islam LP
Madrasa Himayatullah Islam
LP School.
Umji Shillong. Tom, no?
There's the school.
Submits that. Eastern School has conducted themselves in a manner unbecoming of his post, inasmuch as appointments have been made illegally. Stop. he submits that on these allegations, FIRs have also been lodged and resolutions adopted by the school, by the present management committee to remove him from the post of secretaryship. However, he further submits the approval has not been forthcoming from the, what's the respondent number?
4.
Number 4, who in fact has issued the impugned letter dated
8th November.
2023.
Page 34.
Impugned letter dated 8/11/2023, whereby the management committee instead has been instructed to allow that there should be no change in the members and to allow the concerned authorities to conduct proper investigation. So, Mr. Engineer submits that the respondent number 5 by resolution has since been removed, and as such, this has created a problem in the school with regard to the release of teachers' salaries and operation of accounts of the school. So, we have therefore prayed that in the interim, the impugned letter dated 8 November 2023 be stayed, and that the newly inducted secretary, he's a party here?
No, he's not a party.
That he be allowed to discharge the chief secretary, and so that the teachers, they may not be inconvenienced. So, next paragraph. MSD Yangi Leonard AAG submits that the incidents for which allegations have been leveled and FIR filed related to the year 2021 during the period of the earlier management committee, and as such, and management committee, and therefore at this stage no interim orders are called for. So he further submits that as the matters under consideration investigation, the same should be allowed to carry on. So I've heard the counsel of the parties and perused the materials that have been placed today before this court. So no doubt is the fact that there has been some serious allegations leveled against respondent number 5, and that a police case being this case is also pending, and is it under investigation?
Investigation is going on.
Undergoing investigation. Stop. The impugned letter on this account, and on account of the present management committee being the constitution of present management committee being challenged, has refused to record the approval. In this view of the matter, no interim orders are called for at this stage, except that in the operation of the accounts, to avoid any inconvenience caused to the teachers, etc., the respondent number 4 is directed to assume charge the same and release the amounts as necessary, so that the teachers may not release the salaries as necessary. Which is a list of clarifications for further orders.
Item number 5.
What happened now?
Please, Your Lordship. Lordship, yes, Lordship. And it is listed. That is listed for the my old petition is listed in the main list in item number 17 in the hearing list, Lordship. But there is a change of circumstances, and hence this writ petition, Lordship. Now, Lordship, during the pendency of the verification of the caste certificate, Lordship, what the department here has done, that is the respondent number 4, 5, and 6, they have withheld the pensionary benefits, Lordship. They are not complying to the CCS rules of 1972, to Rule 9 and Rule 69, Lordship, and also to the pensionary rules of the CCS rules of pensionary 2021, Lordship. Now, Lordship, I'll just take Lordship to the there are also the various office memorandums, Lordship, what they had been given, Lordship. The first will be the annexure here, annexure 6, Lordship. That is my page 22, Lordship. Lordship, This is dated 30/11/2021, Lordship, where the AM has already, it's here, OMS says, the Central Civil Service Pension Rules 1972 or instructions guidelines issued by this department, however, do not provide for withholding of the retirement benefits under any other circumstances, including on account of pending verification of caste.
Before?
This was not, my lord. And my lord, kindly cease the prayer, my lord. In my humble
Lordship,
submission,
let me
the prayer
just-
in the writ petition, my lord.
If I may just be allowed to complete first, Lordship.
Okay. Yes.
Then, Lordship, I may, here, Lordship, even here, Lordship, I don't have any departmental proceedings against me, neither do I have a judicial proceedings, Lordship. Now, in the earlier writ petition, my prayer was only for the issuance of the duplicate certificate, caste certificate, Lordship, because I had lost it. Now, what, Lordship, if I had not come there, then the department would not have looked into it, would not have verified also. Now, they're saying that I come into a reserve post of the ST. But nowhere in their affidavit, in the other writ petition, Lordship, they have placed this, that I come under the reserve post. If
What bearing does it have on a pensionary benefits?
pensionary benefits, yes, Lordship, during the verification.
You misled authorities, the Scheduled Tribe, and you obtained the post, that's why your entire service is in jeopardy. Is that what you're trying to say?
But as far as pension, my lord, that's what we filed our affidavit, my lord.
Lordship,
If
they
somebody
cannot do
enters
that,
service
Lordship.
on the basis of ST certificate to a reserved post, my lord.
Whatever it is, but then the certificate was issued by competent authority. Notwithstanding anything like you can't
that is pending.
impute that they have misled the authority something, no.
It appears, my lord, the ST certificate submitted by him is suspicious, my lord.
Now, after how many years you served?
After 40 years, more or less 40 years, Lordship.
My lord,
Now
that is-
they're coming here
My lord,
with
that
this
is
plea,
that,
Lordship.
that is the subject matter of other writ petition, my lord. My lord, kindly see the prayer, my lord, in the present writ petition, whether such a writ petition is maintainable, my lord. Direct the respondents, especially so and so, to release the pensionary benefit petitioner without depending on the outcome of WPC number so and so.
Oh, disregard the prayer. Pay his pension.
My lord, I have submitted before your lordship, my lord. We have processed the pension papers, my lord, but we have withheld the release of pension because once you pay, my lord, the recovery will be very difficult.
Or at least 50% then.
50% provisional they have to pay, Lordship. But here this
My lord,
also they're
the
not
other
doing,
matter is
Lordship.
ready for hearing, my lord. It can be heard immediately after vacation, my lord.
What's he going to do now? He's going to starve.
Well, he is retired just recently, my lord.
Retired, Lordship, on the 31st August, Lordship.
31st, 2023, my lord. September, October, this is only 4 months, my lord.
And Lordship, with regard to that, I am placing a judgment also, Lordship. This is not it's not a bounty, Lordship. It's a
pension, no.
Pensionary
you don't have to go there.
benefits, Lordship.
It's your right. It's not a bounty.
We are not saying we will not pay, my lord. But they have to comply with the formalities, whatever the formalities are there.
Lordship, there are various office memorandums which I have placed, Lordship, here.
How much can you release? 50%?
My lord, at this stage, my lord, kindly, my lord. My lord, the first writ petition can be heard, my lord. That is pending for hearing, my lord. And that is in fact listed today also. Immediately after reopening, my lord, because the state also has a role, my lord, in issuing a duplicate certificate.
What role does the state have to play?
State has to issue the duplicate certificate, my lord. His case is, my lord, he has misplaced the original certificate. So he has to obtain a duplicate copy of that, my lord.
Now, Lordship, if I had not informed it to this, Lordship, if I had not lost it, that means they would not be aware of also, Lordship. They would have continued to do so. So now, just because I lost it and I have placed my list grievances, so they are coming with this plea, Lordship.
See, you cannot withhold pension.
But your lordship will decide in the other writ petition.
You cannot withhold pension.
That is the subject matter of the other writ petition.
You cannot. Whatever it is.
But after hearing the other writ petition, my lord, your lordship pass an order, will comply with it.
What will happen? Will heavens fall if you pay him pension?
But they can wait for 1 month. He retired only 4 months back, my lord. Not even 4 months
So 4
completed
months,
now.
Lordship, then I will not starve, Lordship. I'm not having any other sources, Lordship.
My lord, this matter requires consideration of your lordship, my lord. Whether a person who enters service on the basis of ST certificate and if later found that he is...
No.
He does not
We're not
belong to
there
ST
right now.
category,
We're not there. We're not there at all. It's not a question of like his genuineness of certificate. The thing is that he entered service maybe 40 years ago. He served his entire life. He lost his original. He's asked to duplicate. State's getting complications for him.
My lord, at the time of processing of pension, he was asked to submit all the original documents, my lord. That is where
exactly.
Lordship, if that was the case, Lordship, he was the incumbent
But
out here was, Lordship,
I'll file a reply to
outstanding.
this,
He
my lord.
received the press also, Lordship, the scheme. Now they're coming with this, Lordship. Lordship, even this OM also, Lordship.
How they can come with this kind of prayer, my lord? My lord, any relief granted in this writ petition will be against the order passed by your lordship.
Lordship, but provisional, I am entitled to get, Lordship.
My lord, in other writ petition we have placed before lordship.
Lordship, it is in my petition only, Lordship. This is at page 19, Lordship, Annexure 5. The relevant para will be last, Lordship.
Page 20, my lord. Yes. Page 19, my lord, last sentence, last paragraph. Pursuant to the order dated.
Pursuant is here, Lordship. Pursuant to the order dated 29/8/2023, the respondents number 4, 5, and 6 have processed the pension papers of the petitioner. So today, Dr. N. Muzika, learned DSG, has referred to the affidavit filed on behalf of the said respondents and submits that as the main relief claimed is against respondent number 1 and 2, and as the question of a grant of scheduled tribe certificate is still not resolved, he prays that though the papers have been processed, the release of pension may be subject to the result of the writ application. This is what they have prayed, Lordship.
Remember here, you file affidavit then.
At least, Lordship, at provisional, at least 50%.
This is only the last. You should have filed it at least 1 week before. Then you would have got orders before vacation.
Because, Lordship, there's...
SK Improvement Council petition issue notice.
So it may be clubbed together, Lordship.
Yes. On behalf of Ms. MSZ Inokanvi, GF 1, 2, and 3, and Dr. N. Mozika with so-and-so is present on behalf of the other respondents 4, 5, and 6. No as further is called for. This immediately out of vacations together with WPC 276 2023 for consideration.
Highly obliged.
Item number 6.
Yes, Mr. Jha.
My lord. My lord, here the petitioner challenges the posting order, my lord. Posting order. The normal tenure of the, my lord, is 3 years in terms of their own guidelines, my lord.
Where's the guideline?
My lord, it's ROI, my lord, page 55. And my lord. Annexure 7, my lord.
Yes.
Page 55.
Where is it 3 years?
My lord. 3 years. It says, my lord, if I take you, my lord, to page 58.
Where is that?
58, my lord. Tenure and posting, my lord.
Maximum 3 years.
My lord, irrespective. And she, the petitioner has been for the 3 years, my lord.
Where?
All where. Wherever the petitioner has been posted, my lord. Wherever. So, even assuming, my lord, not admitting, my lord. If I take, my lord, to the posting order, my lord. Annexure 4, my lord.
Annexure 4.
My lord.
Oh, Annexure 5. For page what?
My lord.
Page 44.
There are two annexures marked. 44 is Annexure 4, Annexure 3. 45 is Annexure 5 and Annexure 4. I should delete the earlier annexures, whatever. What annexure is it? You've seen the photocopy, Mr. Jha?
My lord.
It shows Annexure 5, Annexure 4, 45. Annexure, page 44 is Annexure 4, Annexure 3. Which one?
Annexure, my lord, Annexure 4, my lord.
Which one? Page?
Page 44, my lord.
That's Annexure 4, not Annexure 3. You see there, you written Annexure 3 also below, right? Should cancel it out. Excuse me.
My lord, page, if I take, my lord, page 42, my lord. Annexure 2.
Not 44.
Not Annexure 2, my lord.
Yeah, page 42.
My lord.
Okay.
Here the petitioner was posted, my lord, to, that is dated 12th January 2022, my lord.
Yes.
My lord. From one place to one office to another office, my lord. At Aresa, my lord.
At?
Aresa, my lord. Assam Rifle.
Okay, okay.
My lord.
Competent authorities approve sidestepping. What is sidestepping? Meaning?
Sidestepping, my lord, they said that it's internal posting, my lord. As per
No, sidestepping of posting. What does it mean, Dr. Mosga, sidestepping?
I would have come across first time.
it's there.
Foreman promotion, maybe.
Competent approve sidestepping of posting.
Approved the side posting in respect to VC numbers, petitioner, from Margis to Arishad.
I can't make out, I can't understand this.
Sidestepping, my lord, it's also my first. I have not any sidestepping, my lord.
What's sidestepping?
My lord, sidestepping, my lord, as per the as per the averments here, my lord. In the from Argis on the top it is written, my lord, sidestep posting, my lord.
What sidestep posting? What sidestepping?
But my lord, I don't think that is the impugned order, my lord.
Impugned order is, this is not, my lord. Impugned order is at page.
What do you mean sidestepping?
Sidestepping, my lord, it's from one office to another office.
Sounds like a dance move, no?
No. From one office to another office, my lord. It's a sidestepping.
Sidestepping of posting. Sidestepping means of overlooking, maybe. What do you say?
I'll require instruction in that one.
My lord, sidestepping, as per the instruction, means from the petitioner, my lord. It's from one office to another, but it's still termed as a posting, my lord.
Sidestepped.
First time I've heard it. Civil jurisprudence, I think
Nothing,
first
my
time
lord.
sidestepping.
Even not in army, my lord. Not.
Okay, yes.
Even assuming on this date, my lord.
What is this?
My lord, 12 January 2022. The 3 years is in 2025, my lord. The petition.
No, this one is that you've kept in the same place.
My lord.
You kept in the same place, sidestepped, you kept in the same place, that means.
Even, my lord.
Okay.
The petitioner joined the DGR, the Assam Rifle. He came at Shillong on 17th.
And what is this, this request for non-issuance of posting order of sidestep?
My lord, the
I was
representation.
totally confused.
That's a representation submitted by the petitioner, my lord.
We said same office.
Argis, I may be allowed to work in the same office, my lord.
No. As approved sidestepping posting of Srimati Bharti Swain from so-and-so. Sidestepping means in organizing interest. I just can't make out. What have you said in your pleadings?
My lord, we say that this letter was also cancelled by. They have cancelled.
Sidestepping.
My lord. That is at Annex 4. On being a representation filed by the petitioner, page 44, my lord. The first line, my lord. Refer number such and such, letter dated 12th January 22, is hereby cancelled, my lord.
Where's the impugned order? I'm afraid, Mr. Jha.
Impugned order is at, my lord, Annex 6.
You transferred from where to where?
From Shillong to 44th Assam Rifle, my lord.
Khonsa.
Khonsa, my lord.
At Nagaland?
My lord. It's a premature
Your movement
transfer.
already 30 September 23.
Not yet, my lord.
This is the order of August, my lord. We are in December now.
August, but still the petitioner is here, my lord.
totally puzzling.
Petitioner is serving, my lord. The only taking advantage of the vacation, my lord, because we have given the representation that has not been considered. Issue and
so where retain what is where you say that? I don't understand. Really sorry, but
my lord, page 15, para 32, my lord.
1 second. Is the current lang?
Even 31.
Can you put his voice down? You can instruct your additional advocate general outside. What to do this case?
My lord, the difficulty that will arise, my lord, page 54, your lordship kindly sees, my lord. At serial number D is the petitioner, my lord. She has been posted to 44 Assam Rifle. And serial number B, my lord, somebody has been posted out from 44 Assam Rifle. So there's an exchange, my lord.
Why did he come the last day? You can't get instructions also.
My lord, I have filed a representation, my lord.
The last day, Mr. Jha.
My lord, if the move order has not been issued till date, my lord.
Even then, we can't make out head or tail of the petition, that's why. Or know what's head side step also. I can't understand also whether what's tenure. Tenure is not mandatory or it's not a statutory, requirement that you have to serve 3 years in the present and place of posting. Maximum of 3 years.
My lord.
Before your tenure gets over you, there's no harm in being posted outside.
My lord,
so apart from that, there's no other ground you've made out. Only that you've not served for 3 years. And the fact that whenever posting earlier you had 3 years, there's no ground for stopping transfer.
My lord,
Is there any malified?
It's
Is there any where's the malified?
tantamounts to, my lord.
How is it? Is it punitive in nature? If satisfied a court that's like a punishment, or that orders were malified, or that something, then yes. But then nothing here except sidestepping, which now so I can't really understand.
My lord,
my
premature transfer, my lord. Their own policy say that 3 years, my lord.
I heard Mr. Arjha. No interim orders.
My lord, as of now.
Otherwise, if heard Mr. Arjha, counsel petitioner, issue notice, Mr. Dr. Mosikal and DSG also then accept notice on behalf of the respondent for notice called for. The matter, the petitioner has sought to challenge the movement order dated
17th August. Posting order, my lord, not movement order.
Order dated 2023, whereby she has been posted from headquarters, DJR, headquarters here, to
44th Assam
Rifles at Khonsa, Nagaland. So the main grievance is that the tenure of posting as stipulated by the record of instructions. It's called record of instructions.
Record of ROI, my lord. ROI 1 of 2016, man.
The petitioner should serve at least 3 years. That there should be at least 3 years tenure in any place of present posting. So, list this matter out of vacations.
My lord, as of now, no movement order has been issued, my lord.
Respondents had to reply to respond to reply to the representation. No replies yet.
My lord.
To address representation of the petitioner at the earliest.
And my lord, no movement order has been issued, my lord.
So challenge. is challenging an order, transfer order dated
17th August 2023.
Pune. At Khonsa. In any place of posting. Yes. So, it is first submitted that no movement order has been issued as yet, and the representation that has been filed has remained unanswered. Yes.
My lord, till that time, till
we can't.
My lord, status quo to be maintained, my lord.
Let him answer representation.
My lord.
Because you see, Mr. Jha, suppose other person has moved.
No, my lord.
You can't click this location. Yes.
It is not moved, my lord. I'm stating on the bar, my lord, at bar, my lord, on the instruction of the petitioner, my lord.
Yes.
May it please your lordships. My lord, this is a case pertaining to seniority, your lordships. What happened here, my lord, the read petitioners, my lord, at present they are holding the post of vice principal, which belong to, my lord, grade 1 of senior school service, my lord, governed by a statute called, my lord, Meghalaya School Service Rules, lordships. Now, my grievance is that, your lordships, we have entered service, my lord, between the period 94-96, my lord, on the recommendation of MPSC. Our initial entry in the service was as assistant teacher, which belonged to grade 2 of senior school service. Now, so far these private respondents are concerned, my lord, I am agree by that. Private respondents are concerned, my lord, they came to occupy, my lord, different position, my lord, including the position of sub-inspector of schools after us. Now, sub-inspector of school and assistant teacher, my lord, they belong to the same grade, grade 2 of senior school service. And at one point of time, these posts were position were interchangeable. And all were by direct recruitment. So admitted position is this, my lord, they entered the service in grade 2. We also entered in the grade 2, but our entry was earlier than them. So when our promotion, my lord, the promotional avenues are also same. Now what happened, my lord, except that in 2012 rules, my lord, it contemplates that so far the sub-inspector of schools are concerned, my lord, on completion of 8 years of service, they could be redesignated as additional SDSU. That is a higher post which belongs to, my lord, grade 1 of senior school service at par with the vice principal after 8 years. Now, my lord, so far we are concerned, we are assistant teacher, my lord, belonging to the same grade as SI of school. The rules say we are eligible to be promoted after 8 years of service. So, my lord, our entry in the service in 94-96, now we became eligible for promotion, my lord, way back in 2002 and 3. Now, we realized, my lord, what would happen. So we have been constantly representing that promote us in time. So, my lord, they have delayed the matter. Now, ultimately, what happened, your lordships, some of the inspector or sub-inspector of schools, they approached this honorable court. They filed a writ petition. That was before my lord has decided. But lordship has not decided anything. No, they said we have completed 8 years service and we are entitled for redesignation in the higher post as additional SDSU. Now, the state government filed an affidavit and they said yes. They are, and we have taken up the exercise subject to selection. So ultimately, my lord, the state government was about to issue an order with retrospective effect from 2014 when they have sanctioned the upgradations. Now, in the situation, what happened, my lord, many of the vice principals, my lord, they got aggrieved because they were already in place in 2014 and thereafter. So they filed a writ petition, my lord. In fact, I appear in that case. There, our contention is this: it cannot be. It cannot be. It has to be from the date of the DPC, that is 2020. So ultimately in 2020, my lord, they were upgraded. Now, so far this present 3 writ petitioners are concerned, my lord, our promotion was due way back in 2002, 3, 4, my lord. If they had considered our promotion before this 2020, before the upgradation of, my lord, this sub-inspector of his school, my lord, we would not have been superseded in the grade 2. Now, ultimately our promotion was given, my lord, in the year 22 and 23. After 20. Now, my lord, they have come up with 3 seniority lists. First seniority list, they realized they made a mistake. What they did, your lordships, they, my lord, prepared a seniority list showing us senior to the private respondents. We are happy with that, my lord, because how they did it, they have taken into consideration original entry into the service when the MPSC recommended. Okay. We were earlier, so that. Subsequently, they issued fresh gradation list. In the fresh gradation list, my lord, what they did, they have referred to this court's order. Court has never said you treat them as a junior. There they have, my lord, shown the private respondent over the writ petitioners. Though the writ petitioner initial entry much before the... So this is my grievance, my lord. This need to be corrected. And in fact, my lord, I have also filed a miscase, my lord.
For what?
Because further promotion. My lord, at this stage I will say, my lord, on so far the miscase is concerned, my lord, let the government obtain instruction, my lord, notice go. And in the meantime, my lord, only thing I will pray, my lord, if any promotion will make, my lord, it will be subject to the outcome.
Of course, that's
no, but that lordship will make that observation.
I'm appearing for the state response, Your Lordship. 1 to 5, they are private response.
Let take step, the private respondents are there. Heard Mr. SN issue notice returnable in 3 weeks. So Mr. K. Khan and AG with present behalf of respondents 1 to 5. No further notice call upon the respondents. Please take step for issuing the notice to the respondents. So just after vacations for instructions stroke affidavits. In the miscase, this miscase number 244. Miscase, this present miscase has been filed for appropriate interim orders directing the opposite parties not to hold in DPC for promotion of the post of vice principal stroke additional STSEO to the post of junior grade 2 of the Meghalaya School Education Service. Issue notice on interim prayer, just together with the main case after vacations.
Item number 8.
All right.
My lord, this pertains to land acquisition, my lord, in West Jaintia Hills. My lord, the petitioner, the Doloi of Satpatar.
Of?
Satpatar Elaka, my lord. They are the owners of the land, and this has been recognized by the government because, in fact, when earlier land was acquired, my lord, for the purpose of border road.
Which district is this?
West Jaintia Hills.
West Jaintia Hills.
My lord.
Yes.
Now, my lord, this. So 88 to 1991, my lord, the land was acquired for border road, my lord, and that time also 88 to 1991, my lord, land was acquired for border roads at that point of time. Compensation was awarded to the Doloi, my lord, to the Elaka. Now further land was required for Indo-Bangla border fencing, my lord, and in terms of that, several notifications under the law were issued, my lord. Page 70 is one such notice, my lord, section 11 notice. Page 70. The Government of India Home Affairs is pleased to notify the public that the land measuring about 360 so-and-so square meters is required at village Muktapur, Laikro, Hawaii Tila, so-and-so, which falls under the jurisdiction of Jaintia Hills for construction of border fencing from BP number so-and-so, so-and-so, my lord. And subsequently, section 19 notification is page 73, my lord.
71 also? What is this? What is this? Shadow boundaries.
My lord, page 71, lordship will see the name of Doloi, my lord. In respect of all the lands, Daman Lakashyang, Doloi Satpatar has been recognized the owner of the land, my lord. Now, my lord, when the matter was ripe for award of compensation, my lord, the respondent number 3, my lord, he jumps into the fray, my lord, without any documents.
Who is he?
He is Arvind Sutuga, resident of Umsosun, Shillong, my lord.
On what ground?
Without any document, my lord, he jumps into the fray for claiming compensation for this land. And what the Deputy Commissioner does, my lord, the impugn order, take your lordship, my lord, page 85, my lord.
Yes.
This is a proceeding of the public hearing for the special notice under section 21 of Rect so-and-so Act. Attendance, enclosure, and Lecture 1. The hearing was chaired by the Deputy Commissioner in charge West Jaintia Hills, Srimati HML Kinta, MCS. Concerned landowners or representatives were present. The chairperson welcomed all who were present and meeting, and all matters discussed were as follows. The process of land acquisition for the concerned stretch was completed in the name of Doloi SIP of Elaka Satpatar. The process has now reached the award stage. The office of the Deputy Commissioner received objection from two parties, namely Sri Arvind Sutuga and Sri Bester Saleh. The parties were briefed that they are to furnish the relevant documents which will be sent to the Special Judicial Officer. The chairman also intimated to the objecting parties that this particular matter of dispute is outside the jurisdiction of the district administration. The chairperson informed the parties that the Deputy Commissioner may take advance possession of the concerned stretch for work to proceed. But clause number 5, my lord, both parties requested for a period of 1 month to reach an agreement. My lord, this was never requested by us, my lord. In fact, the Office of Deputy Commissioner is forcing us, my lord, to enter into some kind of settlement with the respondent number 3, my lord.
Okay.
So, my lord, all along, my lord, in fact, I'll indicate one more document, my lord. Page 67, my lord, so kindly see, my lord. This is dated 15th March 22 to Dolo Ilaka Satpatar. In drawing your attention to the subject cited above, your letter number so and so, I am to request you to kindly issue a no objection certificate for the purpose of land acquisition for construction of Indo-Bangla fencing from Muktapur to Jalia Khola covering so and so. It may be mentioned that preliminary notification number so and so. In this regard, I am also to state that as per information received, any compensation is to be transferred in the name of Sri Damman Lakashyang Dolo Ilaka Satpatar Doloisip on behalf of the. In this connection, I am also to request you to kindly submit a power of attorney authorizing. Now,
so
my
what's
lord,
happened now?
Now, my lord, suddenly the respondent number 3 comes into picture, my lord. He goes to Deputy Commissioner without any document, my lord. Now, my lord, this process.
What? He seems he's the owner.
He is saying that he without any document, my lord. And Deputy Commissioner is giving indulgence to the person, my lord.
Yes, Mr. Sen, what is this?
Please, Lordship.
How can a person jump in the middle after all these?
I'll just come to the issue.
When it reached award stage, my lord, that time he jumps in, my lord.
I'll just take your Lordship to the scheme of the Act as well. Kindly see page 69.
Yes.
I don't think there's anything adverse which has been recorded in the impugned order. 69 is an objection which has been filed by the private respondent. This is dated 27th of September 2022. So this was prior to the notice under section 21.
One second. Yes. He claims to be
the landlord of the area, and so on. We are not on the issue whether this has any kind of basis or not.
He's tracing his team to M. Sutangas.
Correct.
Saying that I'm
we're not on the issue whether it is correct or not. We're just on the legality of the procedure. Now, the impugned letter at page 85, kindly have that once again.
Yes.
So this is a hearing under section 21 when objections have been invited. And against this, kindly see the entry number 3. This reads, the Office of the Deputy Commissioner received objections from 2 parties, namely Arvind Sutugna and so. The parties were briefed that they are to furnish relevant documents. They haven't taken any decision as yet. And kindly see entry number 5. This says both parties requested. It's not a resolution which has been unilaterally taken by the DC. Both parties, in fact, requested time to reach an agreement. Now, kindly also see entry number 7.
What are both parties?
It says both parties requested a period of 1 month to reach an agreement. I'm not sure who these both parties are. That is one.
Bhopal might be in this Bester, Salahi and this.
No, as far as Bester, that is recorded in entry number 7. With regards to a stretch of 200 meters belonging to Shri Bester Salahe, the Deputy Commissioner's Office will explore possibilities of awarding the due compensation as there was no objection from any party.
Okay.
Now, this is, as far as the hearing is concerned, under section 23, where parties come and lay some interest. Any party having any interest in the property may raise an objection with regard to the compensation. Compensation is yet to be awarded. Award is yet to be drawn up. This is at a very early stage. Nothing adverse as against the petitioner has been recorded in this particular order. This has only been adjourned till such time parties can arrive at a settlement. If they don't, then the parties have been clearly informed that they'll have to produce relevant documents with regard to their claim. Now, the petition is mounted on the contention that there is a violation of section 15 of the Act. This, I believe, is misconceived. Can you see, Malad, section 11 is the first notification where the government
Yes.
So just the stages of the Act, if Lordship kindly notice. Section 11 is a preliminary notification, which basically is the expression of the government with regard to its intention to acquire a land for a public purpose.
Yeah, okay.
And it invites objections. So those objections are heard under section 15. Kindly see.
Come again to this public hearing. Is under which provision?
21. I'll just come to that. So this is a subsequent stage. The first stage is section 11, which is followed by hearing of the objections under section 15. Kindly have section 15 for a moment, my lord.
Yes.
So this reads, any person interested in any land which has been notified under subsection 1 of section 11 as being required or likely to be required for a public purpose may within 60 days from the date of publication of the preliminary notification object to 1. The area and suitability of land proposed to be acquired.
No. One thing that is here, you see, what is given here is not at the level of the deputy commissioner. What has been recorded in this impugn order is that the parties will brief the furnished relevant documents which will be sent to the special judicial officer. Why? Why the reference to special judicial officer at this stage?
No one's saying that it will happen immediately. They're saying we can't decide the question of title. If at all there is a question of title.
It's already reached a finding that, they can't decide the question of title. They have not even seen a document which has been furnished by this respondent number 3.
Lordship.
You have to see whether there's any basis at all.
Correct.
Reject them, their objection goes.
Correct.
Then there's no question of title.
They are aggrieved with the second finding, where apparently they say they've mischaracterized this. They say they've been directed to settle. There is no direction. The parties have themselves requested time.
It's just order right that, without coming to a finding, you say, I'll send to the special judicial officer.
No, that we'll have to examine whether it is a situation which can be relegated
wrong,
to.
then.
No, we'll have to examine that. I'll take instructions as far as that is concerned.
See, there's a public hearing.
My lord.
The parties show their papers.
Lordship.
If they come to finding that yes, they can't decide, then you send it to the court.
Correct.
Then,
so which is why they're saying that they've been directed to furnish relevant documents.
Saying that the parties will brief the furnish relevant documents which will be sent to the special judicial officer. Why?
To that extent, they may not be correct. I'm saying to that extent. But as far as the question of direction to settlement to settle is concerned, there was no direction as such. The parties have themselves prayed for it.
No, that will not take cognizance of that.
Lordship.
Well, what I pray, my lord, let notice be issued to the respondent number 3, my lord. At least he should indicate what documents he has, my lord. Without
this kind of proceeding also is a half-baked proceeding.
I understand. So, in any case, it is the collector who should decide.
You can't decide, don't decide.
Lordship. So, it is eventually the collector who has to decide this. And right now, I don't think anything adverse has been decided against the petitioner. Can we see from a reading of this particular impugned order?
No, but if it's a land of belongs to this community and someone jumps in halfway when the award's about to be pronounced.
No, which is permissible under Section 21. That's all I'm saying. It is permissible under Section 21.
Exactly, but then the collector, whoever, the EDC, whatever, to take up the matter, should take it, taking that into consideration whether there's any basis on the objection.
No. So which is why
the objections come, they can flying from anywhere.
So if Lordship will kindly appreciate, the objection has come without any documentary basis. So they've been told to furnish documents. Nothing adverse has been decided as yet. That's all I'm placing before the court.
There's already been indicated there that they can't decide it.
That extent I understand. That we'll have to examine. I'll just take instructions whether this is even permissible. But as far as the rest of it is concerned, there's no decision.
Dr. N. Mozika, as a counsel of the petitioner, issue notice. Mr. S. and Senior advocates present. Respondent 1 and 2. Notice issue to respondent number 3. The main grievance, next paragraph, the main grievance of the petitioners here is that when the process for acquisition has been ongoing, and in the notifications itself, the petitioners have been identified as the landowners. At a stage of public hearing, respondent number 3 has entered the fray by raising objections without producing documents. Stop. An order dated, which order dated 22nd November 2023 has been issued, wherein the Deputy Commissioner in charge, Wage and 6, has directed for the parties to furnish relevant documents which will be sent to the special judicial officer. This finding, which is questionable, has been assailed by the red petitioners apart from the direction that the parties reach an agreement within a period of 1 month. So, in consideration thereof, Mr. SN is directed to obtain necessary instructions before the next date. Yes. Just thereafter.
Well, this letter may be kindly stayed, my lord. Till the next date.
In the meantime, note that letter impugned should not be given effect to. You get instructions. You have to instruct them. If they do something, they do it as per law.
Lordship.
Item number 9.
May I please, Lordship? Lordship,
It's
in this...
covered by those cases. Is this that...
this is nil it, my lord. Nil it, Lordship. That was... The petitioners herein were appointed as senior technical assistant, Lordship, in 2011, pursuant to an advertisement dated 18 December 2010, Lordship. This advertisement was published subsequent to an amendment, Lordship, in recruitment rules, wherein all the future recruitments were to be done on permanent basis or deputation, including permanent absorption, Lordship. Now, interestingly, Lordship, except Nilit Shillong Center, the other people employed in other, recruited in other centers, Lordship, have already been regularized, Lordship. For that purpose, Lordship...
You're still working now?
I'm still working, Lordship.
Issue notice. Yes, heard by Espan in the council petitioner. Issue notice, returnable in 3 weeks. Dr. M. Mozikan is accept notice on behalf of all the respondents?
All the respondents.
All the respondents for interest call for stop. This is the matter after on so it is directed that
Lordship.
You want to any security for employment?
Lordship, there is a maze case, Lordship. My services may not be disturbed, Lordship,
yes,
during the pendency of the petition.
Directed that the services of the petitioner be not disturbed.
Item number 10.
Similar prayer, Lordship, in item number 10 also, Lordship. Highly obliged, Lordship.
$11.
What is this?
Well, we have come by way of this present missed case, my lord.
Who's there for the other side? You serve notice?
Mr. Sinkon.
Who's appearing for?
Mr. Sinkon is for the writ petitioner, my lord.
Where's Sinkon? This has not been resolved as yet. This is regarding the Daloi election.
My lord.
Why?
Only because administrator is running the administration, my lord.
Where's Mr. Sinkon?
He's occupied the other courtroom, Your Lordship.
How long has been occupied?
Can this matter come up after?
Sometime.
Obliged.
Supplementary 2. Item number 1.
May it please, Your Lordship.
Yes. Yes, Mr. Sen.
Your Lordships. My lord, we are the leaseholder of plot of land, my lord, covered by 31 CV, Your Lordships. Now, my lord, what happened in this case, my lord? We have been in occupation using as a dwelling house as well as for carrying out our business, my lord. Now, what happened, Your Lordships? There are, my lord, 2 buildings are located in this plot of land. Now, my lord, in between the 2 buildings, my lord, there is a vacant space. In vacant space, my lord, there were some, my lord, temporary constructions were there from before, Your Lordships. Now, recently, my lord, considering, my lord, the monsoon season and all, some minor, my lord, repairing has been carried out. Now, whatever it may be, my lord, this is not, my lord. Now, the question is this, my lord, suddenly we received a notice. No, without our participation. That is my grievance. Without our participation, we received a notice. They said, no, this is unauthorized construction. And while saying the unauthorized construction, my lord, they have touched everything. I'll take my lord to this page. Unauthorized, my lord. That is, my lord, at page, Your Lordship, 30, Your Lordship. Page 27, my lord, sorry. The type copy is at page 28, my lord. If I can read it, Your Lordship. Dated 22nd May 2023. Now, this has been collectively addressed to all the legal heirs, my lord. Well, originally, it was settled in the name of 3 persons. Subsequently, my lord, on their death, the legal heirs came into the picture. Now, it has been addressed to all of them. And then it is saying, whereas you have made the following unauthorized construction in holding number 31 CB, survey number such and such, Cantonment Bazaar such as the part of existing Assam type building, Cantonment Bazaar Road, has been demolished instead of repairing the same and constructing RCC structure building consisting basement floor such and such, and in such floor with height of such and such in the basement floor, and also constructing the staircase to rear side of the existing Assam type building. And whereas the undersigned considers that the aforesaid construction constitutes an offence under 247 of the Cantonment Act. Now, therefore, notice is hereby given under section 248(1) of the to demolish the above mentioned unauthorized construction within.
One second. That means to say that you demolished it and instead of repairing,
yes,
you built this building.
There is not so, my lord. Our contention is this, my lord. There was some temporary structures. We carried out some renovations. Now, whatever.
You made a building.
No, not at all, my lord. It cannot be. How can it be, your lordship? It's not a building. Now, my lord, that's why I think they should have given us an opportunity to participate, my lord. This is a unilateral finding. And then they say, my lord, you remove it. Now, thereafter, your lordship will come to page 30, my lord, annexure 5, my lord. Now, ultimately this come, my lord, 31. After receiving this, my lord, we have verbally informed them, my lord, there is no construction of building as such, my lord. Some minor, my lord, correction has been made with regard to the temporary structure. Now they have issued this, dated 13 December 2023, whereas it has been reported that you have failed to comply with the terms of the notice dated such and such as amended up to the requiring you to demolish the unauthorized construction at the site specified therein within 30 days from the date of the decision which was received by you on such and such date. Now, therefore, take notice under Section 320 of the Contempt Act that in the event non-compliance of the terms aforesaid notice within 15 days from the date of receipt of this notice, such steps may be necessary for demolition of all authorized construction site will be taken at the office. Now, they are virtually, my lord, threatening to done it. Now, my lord, where is my participation? What is your lordship saying? That would be shocking. Instead of, my lord, repairing a Assam type house, if I build a building, no reasonable person in the world will do that. That was never done, your lordship. At least, my lord, our participation should have been there. I have stated categorically in my petition, my lord, without intimation to us, some official make a visit, and without our participation, my lord, they have come to a finding. Now, my lord, in these kind of cases, my lord, mostly comes from, my lord, Cantonment Board. What happened, your lordships? They are concerned with one index, my lord, that is called floor space index. Now, regarding floor space index, my lord, there are other cases also pending before your lordship. What happened, your lordships? The government of India as well as Cantonment Board itself realized ultimately that the space, my lord, limited by the Cantonment Board requests to be, my lord, enlarged. So that has been sent to the ministry, my lord, and that review is still pending. That review is still pending, my lord, and the similar matter, your lordships, which are pending before your lordship taking it. And my lord suffered this appeal, my lord. I am conscious of this appeal. 348 appeal. I have not gone, my lord. For the reason, my lord, this is without any, my lord, notice, without any participation.
From May, he could have gone on appeal, and the last moment today he has come. How can it be, your lordship?
Lordship, we see the date when it was issued.
It was
November and 23rd.
First notice 22nd November 2023.
My lord. Thereafter, 13 December.
Then they didn't respond to anything.
13
Still
December.
They were continuing, then we are
My lord,
forced to give
lordship is very.
You do one thing. Will you suppose it or you file appeal?
No, lordship, yes, no, my lord. What I'll say, no. Otherwise, lordship.
The appeal.
No, lordship want to hear me. Lordship want to hear me on this because the law is very clear. Law is very clear that the statutory appeal will not stand in the way when, my lord, the basic participation, my lord, reason, my lord, I'll satisfy your lordship on that. I'll satisfy, my lord.
No, we're giving you. Relief. They won't act on the 320, section 320 notification notice. They won't demolish it.
No, what I'm.
They've asked you to demolish it at your own accord, or they demolish it, right? Lordship. Fine. Now you have remedy of another appeal. The thing is that meanwhile there'll be no demolition. You file appeal.
Lordship, what I say, my lord, this is the position of law, your lordship. Numerous cases, my lord, we have argued. My lord, when the basic, my lord, participation is not reasonable.
Yeah.
Oh, well aware.
Yes.
Yes.
340 is clear.
Yes.
From May, they didn't prefer any appeal. Then thereafter, we have to give a 320 notice also.
You take recourse appeal, Mr. Sen. We will
My Lord, this is
your protection in
no, Lordship, why I am saying, my Lord, I was conscious of this. Now, the proposition of law is very clear, my Lord, where basic participation is refused, my Lord, under 226
See,
code.
Mr. Sen, that excuse not available to you. Only today is the last day, maybe you'll get some relief. But the excuse not available because your notice came as far back as in May 2023.
Lordship.
And that's a notice of the board is given to you.
Lordship.
Now, what prevented you from taking part in the proceedings?
My Lord, I was never called, Your Lordship. That's how I have.
How do you get the notice?
How, Lordship, they should have initiated.
How do you get the notice?
No, Lordship will see the notice, language of the notice, what the notice say. Notices came to a finding. Before our participation, they have come to a finding. Lordship will kindly say that's
how do you word notices always?
No.
The 248, yes.
My Lord will see, my Lord, 22nd May, second paragraph. The part of the, they have already come to a finding, this is unauthorized. So where is the question of participation? My Lord?
They could have gone.
Why don't you appeal straight away?
Straight away, they could have appealed.
My Lord.
What did you do? What did you do from the period of May 2023 till you got the notice dated 30 December?
No, what did we do? We approached them. We said, my Lord, I've made a categorical statement.
Where's the communication?
Statement I have made.
Where's the communication that you
I have made a statement. I have made a statement, my Lord. Now, Lordship will appreciate one thing, my Lordship. 22nd May, Your Lordship. Before our participation, they have come to a finding and they have said, remove it.
Doesn't matter, right? Maybe they've come to the wrong finding, but then where the communication that you've represented, you appeal against this order which you feel is wrong from 22nd May. You're sitting tight.
Lordship will appreciate again. If there is no participation at all, my Lord, that vitiates everything.
No, it vitiates everything. They come and demolish it one day. Suppose you haven't come to the court today. You didn't come and challenge it that time.
I have come with the ultimate notices. Come on.
Why didn't you come in
December 23?
Why didn't you come on 23rd May then for the court to say that there's already been a predetermined finding?
My Lord, I have approached them, my Lord. I have made a statement, my Lord, supported by an affidavit. I approached them, explained the situation, and I was under the bona fide expectation, my Lord, that you will not act on it. Now, ultimately, this notice has come on, my Lord, recently in December, Your Lordship. No, my Lord, what I pray, my Lord, this is an important question of law. Similar other issues.
There's no question of law involved here, Mr. Sen.
No.
The only thing you're coming is on natural justice and predetermined finding.
FSI, my Lord. FSI, Lordship.
Why FSI?
Lordship.
You're not going to FSI. Let them go. You go for appeal. Let them go for FSI. You make all your grounds there. They'll examine. They'll pass orders.
What I am saying, Your Lord. My Lord, 1 minute. What I am saying, my Lord, similar matters are pending, Your Lordships.
No, those are not similar matters at all.
Similar.
That's with regard to rent.
No. I'll cite. I'll cite. WPC number 34 of 2019.
No, Your Lordship, he is telling about those REIT analogous REIT Your Lordship.
No, not REIT WPC.
What does it say in the WPC?
This Lordship, my Lord, has stayed the proceeding.
Demolition.
Yes, demolition has been stayed.
Show the orders passed there.
We have the order.
You can't show the orders. We're disposing of this matter, Mr.
Well, Lordship, this is still pending.
Your urgent relief, you'll get it.
Lordship is still pending. Well, I'll just produce my little copy of the order.
See, laws have come to the aid of people who sleep on their rights.
Whatever, my Lord.
Simple as that.
But Lordship will see one thing, my Lord.
If you're sleeping from me, carry on sleeping. The house gets demolished around you. Sleep, right? No problem.
Without our participation, the basic thing, my Lord, the participation. Without participation. Only thing Your Lordship will say, may.
Mr. Sen, if you didn't receive any notice at all, and a 320 notice served to you one fine morning,
May. It was served in May, and then why I was sitting quiet. But my only fault, my Lord, I approached them, and I was under bona fide expectation. They will not act on it.
But the only plus point is that they've approached a good lawyer. That's the only thing.
No.
Apart from that, they've not done anything.
The other thing is, since Your Lordship is examining other matter, my Lord, why Your Lordship send me for an appeal?
Why? That's alternate relief.
Other cases are pending, Your Lordships.
Not the same
similar issues are involved.
Your Lordship, those cases were in concurrent finding, then they went on appeal.
Yes, take down. I heard Mr. S.N.
Lordship will give me at least some time.
Of course. What's the period of appeal?
Those things will come. That Mohammed Tayyab and so.
Period of appeal?
30 days was there.
From the order of.
Yes.
Yeah, they have enough time.
He has enough time now. Now time is 30 days time.
Well, if I can pray, Your Lordships, my Lord. If I can pray, I need to please.
A special act which provides the time.
I can just read out that order passed in WPC number No? WPC number, my lord?
Read it out.
34 of 2019. Now it's a notice to respondent number returnable within 3 weeks, keeping in view the urgency projected in the backdrop of the pleadings and the submission made, prima facie case for grant of interim relief is made out. Therefore, status quo, subject matter of the writ petition shall be maintained until further orders.
So what is the subject matter about?
Subject matter, there is also demolition, Your Lordship.
What is it?
Partition name is Yang Chen Dolkar versus Shillong Cantonment Board. This matter is still pending. Why, my lord? This is one of
FSR axis, but
here ultimately all these cases come to
two different things.
This is same, my lord.
No. This is two different things.
Heard Mr. S.N. Leonard Counsel, or I pass orders in chamber. Since I've heard Mr. S.N. Leonard Counsel with the petitioner, as also Mr. S.P. Mahanta, Leonard Senior Counsel with so-and-so, who is present on behalf of
1 and 2
respondents. Number 1. What about the Principal Director, Defence Estate?
I cannot. PD has to know.
1 and 2. Yes, the writ petition has been filed against challenging the impugned notices dated 22/5/2023 under section 248.
248(1) subsection
1 of the under section 248(1) and 320.
1312.
Yes, and orders dated 22/5/2023 and 13/1/12/2023 issued under section 248(1) and 320 of the Cantonments Act 2006 respectively. Stop. The petitioner, Mr. S.N., next paragraph, on behalf of the petitioner submitted that by the first impugned notice under section 248(1), the respondents have already reached a predetermined finding with regard to the purported unauthorized construction conducted by the petitioner in his leasehold, in holding number 31 CBS, that's it, SB, I can't
That's
read.
why survey.
Survey number 15/75 at Cantonment Bazaar, Shillong Cantonment. Stop. He further submits that the respondents 1 and 2 have now served the petitioners with a notice under section 320 of the Cantonments Act directing for directing for demolition of the unauthorized construction within a period of 30 days from the date of the notice. It is further submitted that the entire process has been concluded behind the back of the petitioner without affording him the opportunity to present his case. So we therefore praise that the notices being prima facie illegal and in violation of principle of national justice, the same liability interfered with by this court in exercise of powers under Article 226 of the Constitution, notwithstanding the availability of alternative remedy by way of appeal. So, by Mr. S.P. Mahanta, Senior Counsel, on behalf of the response 1 and 2, has strongly refuted the submissions of the petitioner's counsel and submits that the petitioner had been issued a notice under 248(1) as far back as on 22nd May 2023 and has not bothered to either prefer appeal and has slept over his rights. So, this being the case, he submits no relief would be permissible inasmuch as he has come at the 11th hour, and further that no relief is permissible and no interference is called for inasmuch as provision for appeal is clearly mentioned in section 340 of the Act, for which the petitioner can very well avail of. Stop. I have heard the counsel for the parties. Stop. It is a fact that the notice under section 248(1) of the Contempt Act 2006 had been issued as far back as on 22nd May 2023, whereby it was found that, whereby as per the notice, the construction of the RCC construction of the petitioners was found to be unauthorized and illegal. Stop. It is noted that from the date of the notice, that 22nd May 2023, the petitioner did not take up the matter to logical did not pursue the matter and slept over his rights till he was served with the second impugned notice dated 13/12/2023 under Section 320 of the Contempt Act 2006 for demolition of the said unauthorized structure. Stop. The provision, next paragraph, the provisions as provided in the Contempt Act 2006 is very clear, as much as Section 340. It against any orders of any notice on order of the board is provides for appeals to be preferred against any executive orders. Stop, and that a petition of appeal can be preferred. The Act further provides that on the admission of an appeal, further action pursuant to the impugned notices are usually kept in abeyance. Stop. The petitioner, therefore, having ample recourse to alternative remedy, in fact, is guilty of not availing the same and waiting till the 11th hour as submitted to approach this court under 226. Next paragraph. Be that as it may, however, in interest of justice, this petition is disposed of with the direction that the petitioner is permitted to avail of alternate remedy within the period prescribed under the Act, and that you don't want any further time because you have lots of time. Now is the
today is 20th.
January 13th.
All this Christmas vacation and all.
Till January 30th.
Christmas vacation.
No vacation, only 1 day vacation.
That's why, my lord. But I pray to your lordship, this matter can be taken immediately after vacation, my lord.
There's nothing. There's nothing. Why should we burden the docket with, you have done your best, Mr. Sen. Commendable job.
No, only thing, my lord.
Allowing the petitioner to prefer a statutory appeal under the Contempt Act 2006, and the same should be filed immediately after the ensuing winter. No, give the date before 15 January. Yes.
Delay, if any, my lord, be condoned.
Huh?
Delay, if any.
How you lordship take?
No. And then my lordship will give me the protection. Suspend, my lord. Till then, my lord, I'll
There's
fight.
no need for protection because still have provision of appeal 30 days.
No, my lord. What happened, my lord? They have given 15 days.
Till 15th of January. Stop.
Yeah.
It is therefore directed till the appeal is preferred and taken into consideration. There shall be no coercive action taken against the.
They should not be acted on the impugned notices.
Taken against the petitioner's constructions. Yes.
Till 15 January. Deeply obvious.
Second call, supplementary list, item number 3.
What is this, Mr. Khan?
My lord, this is regarding that Lightumra Dorbarsana, my lord.
Contempt matter?
No, my lord. This is a new writ petition, my lord, which I have filed. My lord, earlier beds of writ petition, which my lord is aware, pertaining to the fire brigade ground, my lord. That is Madan Uringhap. My lord, in those cases, when the deputy commissioner my Lord, pass an order, that is 12th November 2022, my Lord.
Where is that?
That is page number 14, my Lord.
One thing, tell the court, what happened? There was a suit filed, what happened to the suit?
Yes, that suit is still pending, my Lord. My Lord, I'll just give a brief background of the case, my Lord. When this order was passed, 12 November 2022, my Lord, the private respondent herein, my Lord, they came before this Honorable Court by WPC challenging this order of the Deputy Commissioner. This order of the Deputy Commissioner says, as far as the uses of the playground is concerned, what it says is, the status quo may be maintained as far as uses of the ground is concerned, which includes established procedure of obtaining NOC from the Darbarsnam and permission from this office, subject to all other conditions. Now, when this order was passed by the Deputy Commissioner, the private respondent approached this Honorable Court for setting aside this order. And in the interim, my Lord, single judge, he has passed an order staying this order of the Deputy Commissioner. Thereafter, my Lord, the Limekra Darbar, they have preferred a petition, my Lord, applications for vacating this order, stay order of the Honorable Single Judge.
Yes.
And then thereafter, my Lord, this court has vacated that order, and against the order of the vacation, my Lord, they have preferred an appeal before the division bench, my Lord. And Honorable Division Bench, my Lord, did not interfere with the order of the Deputy Commissioner. Did not interfere, and it held that, my Lord, the facts involved in that particular case, it's a disputed question of facts. Therefore, it cannot be adjudicated in a writ proceeding, and therefore they were directed to approach before the civil court. Thereafter, my Lord, the private respondent approached before the court of the district council, and then they have also filed an application for ad interim injunction, my Lord, which was rejected by the Honorable District Council Court. Now, even thereafter also, my Lord, time and again several complaints have been filed before the authorities by the private respondent, and as a result, my Lord, what has happened recently, there was applications, my Lord, which was filed for seeking permission for Sankutsnam, my Lord, because it starts from that particular ground itself, my Lord, every year. Now,
no permission from whom?
Initially, the permission was sought from the Darbar. Permission was granted, that is at page number 66, my Lord.
Yes.
And thereafter, as per the established procedure, permission has to be sought from the Deputy Commissioner. Now, at the last moment, my Lord, the Deputy Commissioner, she has not granted the permission for that rally to start from there, my Lord. And what has happened is, they have granted permission only in that small portion, that is the park area, to start from there. And the ground which, my Lord, they have given verbally is because there is a litigation. Now, as far as litigation is concerned, there is no such direction that Deputy Commissioner is not supposed to give permission. Now, it is violation of the order of the Honorable Division Bench as well as the order of the Deputy Commissioner himself, my Lord.
Yes.
Now, this, because, my Lord, the Deputy Commissioner, my Lord, is refusing to grant permission in such a manner, and
where's the refusal?
My permission is here, my Lord, but this permission was granted only in that small area. It is creating serious problem, my Lord, and this place, my Lord, has been used for public interest, my Lord. It has created a lot of problem, my Lord, for the general public.
Where is Mr. Kanta? He's appealing.
My Lord, the notice has to go, my Lord.
No, see, what via media do you want then? What is
I want, my Lord, direction to the Deputy Commissioner that they should not refuse permission, my Lord.
In what manner?
Now their only ground is that civil suit is pending. My Lord, there is no such direction to the court, to the Deputy Commissioner, that they should not give permission.
What's your way, Priya? Now it goes to Limekra Darbar for request. Then after that?
After that, my Lord, as per their own order, my Lord, first we have to obtain permission from the Darbar, and thereafter, my Lord, permission from the Deputy Commissioner. It is as per their own order. And that order was never been set aside by this.
Are you seeking a direction that whenever a permission is sought for, should automatically be given?
No, it is my permission is not that, but only on the ground that the cases are pending, they cannot refuse their permission, my lord.
Okay, yes. Where's Mr. Kenta? He's not here.
He's not here, my lord.
Where's the order of division bench? He's saying.
The order of the division bench is.
No, but then like the institute, there is no order. Where's the order of the district council rejecting injunction?
My lord, that is the operating part is at page number 61, my lord. Page number 61, paragraph 23. Based on the observations made herein above, no interim injunction can be granted in favor of the plaintiff.
No, but see, the order of injunction says, furthermore, no impediment should be caused by the party for the suit lands, playground, and not activities without consent. Yes, Mr. Kenta. See, the thing is that, see, if status quo is maintained, then the deputy commissioner should not unnecessarily just give conditions and all. If it goes through a proper channel, they have to examine it on its own merit and give permission. When the case is pending, like yes.
With Divi's order.
Yeah, but Divi's order, yes.
Division bench did not interfere with the
should
order.
not, I mean, the deputy should not say that suit is pending this and that to other parties.
They are having all sorts of program, Your Lordship, beyond the purview or mandate of the judgment of the division bench. It is for that reason that we have opposed parking, sometime for holding some programs of from Naga Association, all those programs which are not sport activities. So we had written to the Deputy Commissioner to provide us those permission granted earlier. They were holding some program regarding late R.G. Lingdor's demise, 1 year's anniversary. That also is not part and parcel of that division bench.
No. That's odd fair or two means a trade fair.
Trade fair.
Doesn't mean odd fair or two, you understand, is a trade fair that you have objection to.
Yeah.
That's not about other things.
Other things, it was never restricted.
It's all public interest.
Right.
No, Your Lordship, we strongly oppose. Suit is already pending.
Suit's pending, doesn't matter. It's all. See, the thing is that there's no orders prohibiting the usage of the ground per se. Correct?
Right.
Yes. So even other functions, why can't you hold it? There's no other ground. Where's the open space around that area?
No
you might say I might be prejudiced. I am not. The thing is that like, if you have a case in your favor, court will pass. You have to in accordance with law. But if they can use, why they can't use it? Why can't they use it for? I mean, like for like you say that R.G. Lingdor's memorial.
Even for church procession also, my lord. Sometimes this is used for parking, my lord.
Going for title as directed by the Honorable Division Bench. At least we should be taken into confidence also when they are holding all sorts of programs. We are not, we are beyond the purview of the division bench mandate. Now they are giving permission for parking. They are giving permission for so many other things. That is some
parking public interest. Necessary. See, you can't those things which are usual costs. Only if it's extraordinary like a trade fair or something, maybe yes.
Yes. That
unless we are taken into confidence, we are definitely strongly opposing the lordship. Anything beyond our knowledge.
You have no injunction in your favor. How can you oppose? There's no injunction. There's no. I've seen the order of the council court. There's nothing to say that you have. Any rights have been determined as of now.
Nothing, my
No,
lord.
there is an opportunity being given to file show cause. They have not filed show cause. Even in spite of 3 months have lapsed. They have not filed it in.
Fact remains, my lord. Matter is pending.
Now what they are trying to do? They are trying to go by the back door. If we want some permission, come to the civil court. We are also there. Now regarding this granting, I mean, I do not know what exactly is the case about. At least if notice is given to us, we'll be able to.
Notice may be issued.
At this stage, any interim order.
Notice will be issued. But the thing is that it should be in terms of division bench order, also in terms of the earlier orders. That's all. That
yes.
The status quo should maintain and the use of the ground should not be limited. As given by division bench only?
Yes, my lord.
Lordship, in fact, the division bench did not restrict holding of any other programs except 2 odd fair in a year.
That's a trade fair.
That trade fair, my lord, we are obliging.
We had given permission for holding a fair. They opposed, and he came before this court to file a contempt petition against us.
No, you don't have any. But as per the orders only that it has to go as before. As the orders that
Established procedure of obtaining NOC from the Darbar and the Deputy Commissioner, my lord. That is the established procedure. That is the established procedure, my lord.
I strongly oppose, Your Lordship, any interim order at this stage.
No, there's no question interim order. The question is just go on as it was. That's all.
Yes, yes.
Lordship, I strongly oppose for any interim order unless notice is unless we are given a chance of being heard. That's all.
We'll pass orders then. Heard Mr. Jensen Kon and the counsel petitioner. Mr. Sen, what do you have to say?
So the DC's office is being used as a battleground by 2 parties. So I think the confusion is with regard to the order of the division bench and the trial court. Suit is pending. Lordships will decide whatever is in the interest of the public.
Pending. The only thing that concerns this court right now sitting here is public interest.
Correct.
That's the only thing. We're not bothered about the contending rights of,
That's of prime importance.
Mr. Vivan's kind of, but the only thing that in public interest now, that ground is there. I mean, like, why shouldn't it be used?
Yes.
Remember, there was another case, the St. Peter's ground, which took like how many years? It was, like the students allowed to use it. There was fencing. There was. I mean, you don't want it to come to that extent,
Yes, my lord.
That's all.
Your Lordship, if we are in a no, they also approaches us. We will not say no.
See, we can't pass orders over and above that. The matter is the civil suits pending, Mr. Kinta.
Let them establish their rights there, my lord.
Then I can't start determining rights here in red jurisdiction.
That's exactly
then
what I'm
that's what this court is exactly trying to say also. This court is only trying to maintain public interest, that's all. So that both of you don't create unnecessary problems for the public. That's it. We are part of the public.
I am the
Right.
title holder.
Forget, we're not talking about your holder.
I'm the, now,
See,
they are
we're not talking about your title.
contending
We're not talking about your title.
We are contesting this.
We're not talking about your title.
Not deciding any title.
Lordship, how
We're not talking about we're not bothered by your title. It's come to the jurisdiction, we see if it's the public interest, the rights of general public being affected by the dispute. Yes or no?
Lordship, unless I'm given a chance of being heard or notice.
There's nothing here. The only here says that to allow to use as before. I mean, as the orders of the division bench. That's it. We'll give you notice. I'll take down. Mr. Insekon, counsel the petitioner. Mr. Essen is present on behalf of the respondents 1 and 2. You take notice today? No. Then you don't take notice, you can't make submissions.
That's it. I've been asked to say something. I stood up.
Yes, though Mr. Vijayakanta is present on behalf of who's representing respondent number 3, he prays that formal notice be sent to the respondent number 3 to enable his formal appearance. So, though some submissions have been advanced. Will you call his submissions? No. There's a formal notice now. Next prayer. The prayer of the petitioner, which is the Darbar Shamam Kra, at this stage is the response number 2. While considering permissions for holding programs at Madan Yorong Hep, Laim Kra, Shillong, has sought to deny permission on the ground of pending litigation, which is the title suit filed by the respondent number 3 against the petitioners. Next paragraph. The ground, as can be made out and from the earlier orders of this court, both in the single bench and the division bench, is used for public purposes. And as per the last order of the division bench, there should be more hindrance to use of the ground, also for permission to obtain for holding one odd fair or 2. Stop. In this view, the matter, because of the court, as the usage of the ground is in public interest and in interest of the community as a whole, it is directed that the response number 2, while considering any permission any prayer for grant of permission are to take into account that there are no orders operating presently in a title suit that prevents or bars holding of any such program. The decision, and if any retained permissions were taken on the own appreciation on a case-to-case basis. So, just after vacations, yes.
Obligement.
Item 11.
My throat's gone. Over. This is the last matter. Motion. Yes, Mr.
My lord, we have come for modification of the interim order passed by Lordship, my lord. Well, basically we have come because the administrator is running pursuant to the order passed by Lordship, my lord, for almost 6 months now.
So what's the problem, Administrator?
But the problem with Lordship, we only seek modification to the extent that to allow us to appoint an acting Dolai, my lord.
No money for Manfred also.
My lord.
What's JCC doing?
My lord, first of all, we have objection, my lord, as far as this prayer is concerned. My lord, however, if my lord District Council agrees to appoint the acting Dolai in terms of the order of the Honorable Supreme Court and the law laid down by the Honorable Supreme Court in that case, my lord, then we have no objection, my lord. However, if they are not following that order...
No, that is asking for final disposal. That's not a consideration right now. They're saying that they're saying that you want to remove administration and appoint acting Dolai because you can't look after administration.
My lord.
Is that admission the part of the District Council that there's a breakdown of entire administrative machinery?
My lord, also because in terms of rules, my lord, the administrator can only be appointed for 2 months. For 2 months, my lord.
Doesn't matter. It's a court order.
Of course, the matter is ripe for hearing, my lord. Is it the hearing stage?
Yeah, my lord, matter may kindly be heard, and then if any objection need to be filed, I'll file, my lord, as far as.
Because acting the law again might create other
problem, my lord.
You take a call.
My lord, already pleading has been exchanged. The matter is coming already fixed. I think February 5th, if I'm not wrong. Let the matter be heard, my lord, finally.
This like the miss case 239/2023. This miss case has been filed seeking modification of the order dated
19/5/2023,
whereby an administrator has been directed to be appointed by the applicant District Council to administer Rimbai Eleka. So, Dr. M. Muzika for the applicant submits that due to severe financial constraints, the District Council has position to continue with the administratorship and prayers made for upon acting Doloi. So, Mr. M. Sungkon for the opposite party petitioner submits that he prays he may not file a reply and also submits that as the main matter is ripe for hearing, this miss case listed together with the main writ petition after vacations. Accordingly, this is matter for consideration. 1 month was, what is the problem with this council?
Yes.
1 month, I think.
Obligation.
The public are facing difficulties.
My lord, after a month, my lord, matter can be finally decided.
It's border area, my lord. It's very difficult for us also, my lord.
Why?
Members of the
No tangible authority to go to. I understand, we understand.
Yes, the Act provides, my lord, that administrator can run for maximum of 2 months only, my lord.
They have already exceeded that period, my lord. And another only 1 month.
EC decide, my lord, appoints, because the Act...
My lord, I have strong objection in that regard, my lord.
See, Mr. Nombri, you don't want to create another issue. Upon acting Doloi, then your people come running again. We don't want this acting Doloi, remove him. And then it's just yes, that's what happened. He's trying to influence the public. He's not issuing NOC to this part. Same thing, he's not issuing NOC to him. See what happened, you appoint it, he won't be friendly to some people. He's not issuing NOC, he's doing this, doing that, he won't hold a market. We don't want that.
Daily list?
Obligation.
That's why we said administrator.
Obligation.
Yes, Mr. Nyota. Why not fight the joinder? We'll close it.
You see, I just pray some more time, you receive.
How many times you've asked?
This is the second time you receive.
Okay, as prayed for further weeks and allowed to the petitioner for the activities.
Item number 2.
I have received the counter.
Should we file the affidavit, my lord?
Matter is right for hearing.
Yes, Lordship.
Lordship.
If the party submit the appeal is complete, according this is matter for hearing.
Much obliged, Lordship.
Have to put a threat for affidavits to come in this court to these common advocates. Otherwise, they kept in cool storage. Yes.
Obliged, Lordship.
Item number 3.
In this case, I'm for the respondent of 1. So I'm yet to have the instruction. But
Yeah, 1, 2, 7, 9, and 10, correct?
No.
Are you for? 2, 7. You're for 2, 7, 9, and 10. What about team? Who team Arnab?
May I please, Your
3 and 5?
Lordship?
3.
Your Lordship, I'm for 3, 4, and 5. Power bid.
Who's for 6 and 8? Mr. Kanta, 11 and 12. Who's Kasantiyo for 13?
It's Your Lordship.
None of you filed affidavits yet.
We have filed, Your Lordship.
We have also filed, Your Lordship.
Mr. Devnath, yes.
Yes, Your Lordship, yet to have the instruction in the matter. And I will be in a necessary party, as the formal party.
You won't file?
So if I got the instruction, then I will file.
Number 13?
Already filed.
Has been filed. Except for 2, 7, 9, and 10.
Yes.
Mr. A. Movement prays for respond number 2, 7, and 10. But not for a 2 weeks time to file affidavit. Just thereafter also. It noted that affidavit on behalf of respondent 13 is already on board.
Your Lordship, I would like to make a submission that let the matter be listed along with writ petition number 320.
Let it come later.
My lord, that is separate issue. That,
Item number 4.
Unless they have no objection, then
I'll
yes.
Your Lordship.
Obliged.
May it please Your Lordship. Lordship, so far as state is concerned, we filed the affidavit, Your Lordship.
You have received, Your Lordship.
You received it. You'll file a joinder?
Yes, Lordship.
Yes. Your name?
Didi Funkan. Didi Funkan.
Pardon?
Funkan.
Franken?
Yes, Your Lordship.
Yes. MS DD Franken for the petitioner prays for loud 2 weeks time for the joinder affidavit filed by the respondent.
By the state, Your Lordship. Other respondents are there.
You won't file? MSB Kwan Lang is also allowed, also prays is allowed for the 2 weeks time to file affidavit. Oh, sorry. Then you should speak up. Sorry. OA Bang. You're for response. Sorry. Scroll up. I'm not.
Respondent 5, Your Lordship.
Don't go par khajana. And for number 6? Okay. Take down Mr. Andy Shula Island AG submits that an affidavit has been filed on behalf
Lordship.
of number 1. That MSB Conan Lang is appearing for response 2 and 3. Prays that she will be allowed further to time file affidavit. Number 4? Only if you have to 4 also. 1 and 4.
1 and 4, Your Lordship.
Has been filed, huh? 2 and 3 pays for so and so. And then you are Mr. Jason Krebs entered appearance on behalf of number 5 today. Also prays may have some time to file affidavits. None appears for respondent number 6. Because this is matter of vacation for affidavits by the respondents 2 and 3, 5 and 6. Yes.
Oblige, Your Lordship. 4, 5, same, Your Lordship. Oblige, Your Lordship.
6.
Lordship, before you start item number 6, hearing matters will not be taken up.
If you want to do, we'll wait. We'll choose.
Just want to confirm.
Why have the urgent hearing matter?
That old pension, new pension matter.
Where your government advocate, you won't find them also.
Yeah, here in the court.
My throat is really bad. You understand?
Let it come next after vacation. Much obliged.
Please, Your Lordship. Lordship, this is that matter, Lordship may recall, about earth cutting being stopped. Affidavit was filed, my Lord, yesterday. a very interesting affidavit, my lord, has been filed. On the basis of this affidavit, my lord, the entire matter can be disposed of.
Yes.
Today itself, I'll just explain how, my lord. Lordship, the affidavit reveals that there is a suspicion in the minds of the district administration that I have violated the mineral concession rules, my lord. Exactly how I have violated, even after 2 months, they've not been able to identify or ascertain. But nevertheless, my lord, if I can direct lordship's attention to the rules themselves. Now, this suspicion which they harbor, my lord, assuming for a moment that it is true and I have indeed violated, question is, my lord, what is the action that can be taken against me and who is to take the action, my lord? If lordship looks at 36, rule 36 of these rules, my lord, the last page, my lord. Rule 36 states, my lord, that whoever contravenes any of the provisions of these rules shall be punishable under subsection 2 of section 21 of the Act.
What the Act say?
Act, my lord, is itself is the Mines and Minerals Development and Regulation Act, my lord.
I have 57 Act.
Mines and Minerals Development and Regulation Act, 1957.
Yes.
My lord. So the rules say that any contravention punishable under section 21. Section 21 may kindly be looked at, my lord. Section 21(2) is the punishment, my lord. I'll read, my lord. Any rule made under any provision of this Act may provide that any contravention thereof shall be punishable with imprisonment for a term which may extend to 2 years, or with fine which may extend to 5 lakh rupees, or with both, and in the case of a continuing contravention, with additional fine which may extend to 50,000 rupees for every day during which such contravention continues after conviction for the first such contravention. Punishment is there. Now, subsection 4, my lord. Who is to take action, my lord? Whenever any person raises, transports, or causes to be raised or transported without any lawful authority any mineral from any land, and for that purpose uses any tool, equipment, vehicle, or any other things, such mineral, tool, equipment, vehicle, or any other thing shall be liable to be seized by an officer or authority specifically empowered in this behalf. So there has to be a specific empowerment with respect, my lord. Respondent number 2, executive magistrate, is not that specifically empowered authority, my lord. 4A, my lord. Any mineral, tool, equipment, vehicle, or any other thing seized under subsection 4 shall be liable to be confiscated by an order of the court competent to take cognizance of the offence under subsection 1, and shall be disposed of in accordance with the directions of such court. So, my lord, my vehicles, lordship will recall, was seized by respondent number 2, not an empowered authority, my lord. They have been kept in custody, confiscated for the last more than 2 months without any order of competent court, my lord. Section 22, my lord.
Yes.
No court shall take cognizance of any offence punishable under this Act or any rules made thereunder, except upon complaint in writing made by a person authorised in this behalf by the central government or the state government. So any action against me, my lord, has to be, the root has to be a complaint made in writing by a person authorised in this behalf, my lord. On record, in the affidavit, there is no such complaint, my lord. And more importantly, my lord, who is the person authorised to make a complaint or to take action under this Act? My lord, the answer is in a 2018 amendment. If I can just place that amendment, my lord. Amendment of the rules. Section 2. Yes, in the authorized officer means any officer of the Directorate of Mineral Resources duly authorized by the government for that purpose. So therefore, any complaint, any action, in fact, has to be by the DMR authority, my lord, an authorized officer of the DMR. DMR has not taken any action. It is respondent number 2 who has taken action against me. I draw Lordship's attention to the admission that is contained in the affidavit filed yesterday. The affidavit is before my lord. Lordship has the affidavit. Lordship, so what has happened is on 13th, he took action. He came to my land and seized my vehicles and stopped all the earth cutting. After that, my lord, he prepared a inspection.
Why the next authorized comments?
My lord, that was produced before the court on the last occasion, so I...
Is the price comments which anything? Put form affidavit means you put the price comments and form affidavit, not your next price comments, yes.
Lordship. So, Lordship, as I was saying, he took action on 13th. Thereafter, my lord, he prepared an inspection report and he sent the inspection report to the DFO, my lord. Lordship, I'll just come to it. Possibly, my lord, that inspection report was prepared and sent to the DFO for taking necessary action, possibly because they realized that under the rules, there is no power on them. Page 11, my lord, of this affidavit. This is on 26th October from the Deputy Commissioner. I'll just read the forwarding, my lord. With reference to the subject cited above, I am to forward herewith a copy of the inspection report submitted by Assistant Commissioner Reboy so-and-so in connection with the illegal earth cutting carried out on the land belonging to Shri so-and-so, 13 miles so-and-so, which is self-explanatory for favor of your information and necessary action, my lord. So necessary action, meaning, my lord, he's put the ball in the DFO's court, my lord. I'll just read three portions of the report, my lord. Inspection report on the next page. First line, my lord. First line. As per verbal order from the Deputy Commissioner, Reboy District, Nongpo, for inspection on the 13th October 2023 regarding illegal earth cutting being carried out in the land belonging to so-and-so, so-and-so. So, Lordship, the entire root of the matter is a verbal instruction from the Deputy Commissioner.
If I reply.
Lordship, I'll just file a reply, but I'll just highlight one aspect from here. The next page, my lord.
Because you are filing it's on technicalities.
No, my lord. It's an admission, page 13. If Lordship kindly looks at page 13 of that same inspection report.
Yes.
Page 13, my lord. The third paragraph on page 13. After setting out everything further, it may be stated that the undersigned or the office of the DC, Reboy Nongpo, is no longer the competent authority, he admits, to give permission for earth cutting or to evaluate and assess the amount of royalty paid and quantity of earth ordinary clay extracted. Hence, it is suggested that the same may be directed to the office of DFO, so-and-so, to conduct a detailed inquiry in the matter. So there is an admission on his part that when he started this action against me, he had no authority. There was no complaint in writing that was required. There was no seizure conducted by competent person, etc. The entire root of the matter is on a verbal instruction issued by the Deputy Commissioner, verbal instruction based on no material whatsoever, my lord.
It was permission you got in 19.
Which one, my lord?
Permission for your cutting.
2019, my lord. 2019. And that permission is still valid, my lord. That permission is still valid. If I can draw Lordship's attention to page 35 of my writ petition, my lord. Page 35 of my writ petition. So, respondent number 2, the DC office, has sent the matter to the DFO, saying that you conduct an inquiry. DFO did not ask for an inspection report, my lord. DFO has absolutely no problems with me. This permit, transport permit it is, was issued to me on 20th October. So on 13th, if there was any possibility or any violation of the rules that I would have committed, on 20th October, that is 7-8 days later, I would not have been issued this transport challan by the DFO. So DFO himself has no grievance with me. District administration has initiated action against me without any authority of law, and that is my only one-point grievance, one-point issue that I'm placing for Lordship's consideration in my writ petition. If Lordship looks at page 22 of my writ petition.
No, it's okay, Mr. General, you put your objection, pass orders because we understand the matter.
For the moment, my lord, for the moment, if nothing else, if I'm required to file a formal response also, if nothing else, my lord, my vehicles need to be released.
Release them.
There is no case registered against me. There is nothing on record. Not a piece of paper have I got till today, my lord.
Release the vehicles.
My lord, that is.
On the face of it, there is no authority for that.
But emphasize there's no illegality being committed. He's going to permission. Maybe there's some misunderstanding between the authorities concerned. So you release the vehicles.
Lordship, if I can point out, this is a classic case of putting the cart before the horse, my lord. Usually there is an inquiry, then there is action. First they take action, then they go looking for what is the problem.
No, I'll tell you why.
Yes, my lord.
This is a bigger picture.
Yes, my lord.
Bigger picture is happening in those areas is that there's been, there's been rampant illegal earth cutting, sand mining to feed the construction boom in Guwahati. So what has happened in these places where the same excuse taken, this motion to belong to me, they're cutting earth like indiscriminately. So the district authorities from other cases were done. In fact, I imposed penalty also on those contractors or so on. And then that was upheld, I think, by the Supreme Court also. The thing is that that's why the only deterrent they have is when they see such kind of actions before they think to catch the they seize the food. In your case, it's a case on a different footing.
Yes,
but they don't realize they're taking the same kind of modus operandi. Catching the vehicles and the worms come out from the woodwork.
Appreciate that, madam. My only point.
So that's why.
My only point.
So I understand the why you think Carver, yes, how it culminated in this.
Yes, my only limited point before this honourable court is that action can be taken against me if I violated anything, my lord. But the authorised person, the DMR, has to take action against me, my lord. With all respect, the local administration.
An affidavit has been filed today by the state respondents. And where an inspection report has been imposed. Stop. The inspection report is dated
26th October 2023.
Where's the date given?
Page 11, madam.
Yeah, the inspection report dated 26th October 2023. At the last paragraph, has categorically stated that the Office of Deputy Commissioner Reboy or the person who filed the inspection report, that is the Assistant Commissioner, Reboy District, was no longer a competent authority with regard to permissions for earth cutting or for evaluation and assessment of royalty, and that the appropriate authority was the Divisional Forest Officer (DFO) East Khas Hills and Reboy (D Division). From a perusal of materials on record, it appears that the writ petitioner had obtained permission as far back as on
29th March 2019.
2019 for extraction of for cutting removed ordinary clay for the amounts mentioned in the said permission.
This is actually, my lord, this is not a permission. If my lord will see the content in the
is approval issuance of the same certificate.
Yes.
Yes. And pursuant thereto, where's the other thing? As give it 35 as seen from a permit dated 2010-2023, which is granted to the petitioner the said permit had been revalidated. No. What permit is this? 19/2/2021.
Lordship, that was a previous permit that has been revalidated on this date through this.
No, where's that 2021?
That is not in the petition, my lord. It's a revalidated. It's the same permit, my lord.
Person day 2. It is further seen that It is further seen that the petitioner also revalidated a permit for minor minerals on 20th/10/2023 as evidence by annexure.
My lord, this is part of annexure 3, my lord. It's enclosure in annexure 3.
Bracket page 35. Page annexure 3, a series, and the bracket page 35. So, Ms. Zinder has first submitted that the entire seizure inquiry, the entire seizure of vehicles and inquiry being on a wrong premise and in violation of the mines and in violation of the, my throat's killing me, Meghalaya minor minerals concession rules. So at this stage, so that the whole proceeding being unwarranted and illegal is liable to interfere with and set aside. Stop. And next parameter, Ensign Colonel Counsel Petitioner for the respondent has relied upon the affidavit filed to buttress his submissions with regard to the proceedings that have been adopted by the respondents. Next paragraph. As certain averments have been made in affidavit, this court deems it fit that the affidavit and technical points have been raised on the maintainability of proceedings by the petitioner. This court deems it fit at this stage to call for an affidavit reply to said affidavit filed by the respondents. However, in the interim, as the seizure of the vehicles
Lordship, there are 2 vehicles, my lord. One JCB, my lord.
Of a JCB.
One JCB and one dumper truck.
And one dumper truck belong to the petitioner.
Yes, my lord. Bearing number.
Bearing number.
ML10C 0533.
And a dumper truck.
No, that is dumper truck. JCB, my lord, doesn't have.
And the bearing numbers.
Which are currently in the Bernihat outpost, my lord.
Which are currently in the Bernihat outpost as submitted, being seen to be prima facie illegal and without due process, are directed to be released forthwith to the custody of the petitioner. So the same should be completed within 10 days from date of this order. This is matter for the consideration after affidavit has been filed by the petitioner.
Lordship, also, my lord, the earth cutting activity, the activity of earth cutting, it's a seasonal activity. It has to be done only during the dry season.
Not cutting. You asked only for the vehicles, you got them.
Now, my lord,
Grateful.
is pending from the side of the forest, my lord.
Grateful, my lord.
7.
May it please your lordship. Lordship, this matter pertains to exercise of auctioning the mortgage property, lordship.
Yeah, Mr. Datta appearing for the respondent. God.
Lordship, can you hear me, Lordship?
Yeah, I can hear you.
Lordship, Lordship, this particular repetition is hit by section 30.
Yes. Yes.
May I read, Lordship, of the Recovery of Debts and Bankruptcy Act? May I read, Lordship?
Yes.
Section 30, appeal against the order of recovery officer. notwithstanding anything contained in section 29, any person aggrieved by an order of the recovery officer made under this act may, within 30 days from the date on which a copy of the order is issued to him, refer an appeal to the tribunal.
Yes, we know that. Anyway, I don't know. We'll not say anything about interim order. So, you are entering appeal today only?
Yes.
Yeah, we have our affidavit is ready, Lordship.
Where's the affidavit? You want disposal today itself? You have served him copy.
We could not look at them.
Who are you? What's your name?
Arshang Shai. Arshang Shai.
Mr. S. Datta, together with Mr. S. Shai, entered appearance today on behalf of the respondent and prays that summons affidavit filed in the course of the day. Stop. Objections have been raised to indemnity writ petition as is hit by Section 30 of the Recovery of Death and Bankruptcy Act 1993. Stop. We'll dispose it after vacations.
Lordship,
kindly fix a date, Lordship.
Yes, list the matter on 2nd February. There's no calendar.
Lordship, the interim order may be extended, Lordship.
List the matter on 2nd February for final disposal. Yes.
Lordship,
interim order will continue till next day.
Lordship, and regarding the reply, Lordship, I would like
reply
to...
meanwhile.
Yes, Lordship.
Reply very final meanwhile. But there's no case. There's no case. It will be dismissed the next day. You can take it for granted. Okay? Yes.
Highly obliged.
Highly obliged.
Highly obliged. Yes. Anyone ready for hearing? Mr. K.B. Barasi, you want to do hearing today? In ordinary days also you avoid. Huh? What exactly? One more.
Item number 10.
Let's matter after intervention.
9 also, 10 also. Then, at the request of the parties, 9 and 10. 13.
13. 13.
Please, Lordship.
Yes.
Petitioner, Your Lordship.
Start.
Your Lordship, I believe in this matter, the respondent is required to bring some clarifications on how they reached on the amount.
Your Lordship, my senior told me to ask time for after the vacation.
Told you to do that. Suppose he tell you to do something illegal, you'll do. Yes or no? Yes, after vacation, a prayer respondent, yes.
14.
14.
14.
Yes, MSE 1 young. You want to do hearing today and last day before Christmas?
Your
Yes.
Lordship, I pray that this matter may come up after vacation as the conducting
Yeah, for
counsel.
whom?
For respondent number 3, 4, and 5, Your Lordship.
3 and 5 request of the lawyer for counsel 3 and 5 is a matter of notification, yes. 15.
15.
Much obliged, Your Lordship.
In this case, I'm for the respondent. Since the petitioner is
Dismiss the case. Now appears for the petitioner just after vacation, yes. 16.
16.
16, Mr. Sharma.
My lord, I'm appearing online, my lord.
Yes. You are
Yes,
paying
my
for
lord.
adjournment?
For 16, my lord. My lord, the entire...
Yes.
My lord?
Yes.
Yes, my lord, the case is that, my lord, during the COVID time, my lord, I was working as online. I was working online, and as per the notification of UGC, I was conducting my video conferencing classes and everything. Despite of that fact, my lord, my representation being pending, they have taken those days where I have served as during the COVID hours as non-working days, and they have taken as a leave days. So I am here. My writ petition is for condoning the leave days, my lord. So my lord may take it up, my lord, because it's a your.
You take after vacation.
Yes, sir,
There's
my
no
lord.
urgency.
My lord.
There's no urgency, right? Yes.
No, my lord. No, my lord. Not as.
I request the party list matter after vacation.
Much obliged.
Yes.